The answers you have. I'm just going to welcome you officially to this intellectual property training. My name is Yvonne Abungu. On behalf of Lawyers Without Borders. Thank you so much, Felix, for graciously hosting us today. And I'm very sure that the kind of information we're going to be gathering, even for me as a person, will assist all of us in ensuring that our art is protected and we are able to gain from the intellectual property that we have. There's a lot of misconception that intellectual property is really not anything tangible. It's like a car, like land, like a house. It is actually real property that you need to ensure you protect. When you have a house or a piece of land, you get a title deed to protect it and to ensure that it is beneficial to you and only to you, unless you give another person permission to utilize the same as well. So I'd just like to encourage us that every song, every painting, every design, every poem, performance, every photograph that you take, every innovation, it begins with an idea. But often creators pour their talents and passions and hard work into their craft without fully knowing how to protect what they have built. Today we are about to change that, thanks to Wakili and Wakili. Yeah. Your creativity has value. Your ideas have value. Your work deserves protection, recognition, and a fair reward. Intellectual property is not just a legal concept. It is a tool that helps artists and creatives claim ownership of their stories, negotiate from a position of strength, and build lasting livelihoods for their talent. As we gather here today, our goal is not only to share knowledge, but to empower each other to see ourselves not just as creators, but as owners, as entrepreneurs, as leaders in the creative economy. When artists understand their rights, they are better equipped to seize opportunities, negotiate fair contracts, and thrive in their own terms. May today inspire confidence in all of us, spark new possibilities, and equip you with the knowledge to protect your creativity and transform your talent into sustainable success. Thank you so much, and karibuni.
All right, thank you, Yvonne. And I want to welcome now Wambugu to be able to give his keynote speech as we start off the program as well. Thank you, Mr. Wambugu.
Thank you. Thank you, Felix. Thank you for the invite. Asanteni sana. I think today I'll mix. nitaongea lugha ambayo tutajaribu kusimplify hii maneno at a very basic level. Kwa majina naitwa Wambugu Wanjohi. Mimi niko kwa Council and Law Society of Kenya. Okay. Asante. Niko kwa Council and Law Society of Kenya na one of my agendas to campaign all over the country was bringing tunaita emerging areas na intellectual property is one of them. Intellectual property, I hope mnaelewa ni nini. Ni especially when it comes to, these are creations of the mind. Ile kitu ambayo unafikiria and you can reduce it to a money making mechanism. That is what intellectual property is. Na ningetaka kuambia, nimesikia wenu ni wasanii. Intellectual property it comes to issues kama copyrights. Tunajua usanii na copyright. So you know that copyrights one, si lazima ukuwe umeziregister, si lazima uende ujiandikishe kwa Kekobo, as long as you're making art, as long as you're making music and artistic creations, you don't need to be registering them. And you also know that these are things that unaweza hata kulia hata after umekufa, watoto wako wanaweza kulia, your grandchildren, because they are registered. Once you get copyright, once mtu akufe, it also subsists for 50 years after the death of that person. So there are so many opportunities, and here among them, remember Michael Jackson? Michael Jackson alikufa 2009. There is no artist all over the world who makes more money than Michael Jackson. Anapata pesa nyingi hata akiwa kwa kaburi because of how he exploited his intellectual property, his voice, his image rights, his music. There is now a movie based on his life. So there are so many opportunities in these fields of intellectual property, in artistic creations, and not only that. By the way, ukisikia intellectual property, it's not just music and movies and such things. No, mtu anaweza tengeneza machine hapa which solves a particular problem and it's new in the market. You get a KIPI and then you register it and you can commercially exploit that intention. Not only that, trademarks. Uko na logo mzuri ya kitu kinafanyika, register it with KIPI and you get value. Mtu akitumia for other purposes, you sue them and you get your money. Okay? Haya, hatujamaliza. Yaani najua hii drug, si drug, kuna plant inaitwa mkombero. Unajua mkombero? Mkombero hapa Kenya inauzwa tu na focus kwa barabara. Umeionanga tu. Hizo vijiti. They are very na mnajua, I think unajua purpose yake. Mimi nasikianga tu. But I hope mnajua what inafanyanga ama what people say inafanyanga. Mkombero, kuna watu wazungu pale Romania wanatengeneza juice ya mkombero and they make a lot of money from that. In Kenya unapata ngani vijiti tu. So there are so many things in intellectual property. Sahi kuna watu wanaitwa KEFIS. KEFIS nao huwa na register mbegu. Unajua mbegu hiyo ni intellectual property. Kuna mbegu zingine lazima zipelekwe lab, zinatengenezwa, then ni drought resistant, zinaweza grow anywhere. Those also are called plant breeders' rights and they form intellectual property. So the long and short of it is that intellectual property, it's very bold. Si rights tu za wasanii. So mimi nataka tu kuwafungua macho. IP, as we call it, si issues za wasanii pekee. There's so many opportunities even after you get your utengeneze mambo wako. There's so many other opportunities that you can get. Okay? A good example, see, you watch football, kama sasa hivi na watch World Cup. Sijui kama umeingia social media unapata this video is not available in the country, it's because of the copyright issues. Unapata these guys know how to exploit some of these issues. That's why at a ball always watch to from any stream. Squeeze unaenda kuwatch and those guys make a lot of money. Unapata like a good example, La Liga. Unapata ni timu gani ilikuwa relegated from Premier League? Let's say West Ham ama Wolves. Unapata Wolves ama West Ham walipata pesa nyingi wakiwa namba 19 ama 20 ama 18 kuliko mwenye alishinda La Liga, who is Barcelona. Unapata walipata pesa nyingi because people watch more Premier League, and watching more is people subscribe more, people go to there and watch matches, which means they get more revenue. Okay, so in short, ile kitu nawaambia ni there are so many opportunities. Ukiangalia hata contract za some of the players, you get that player and kwa contract yenye huwa na sign iko na kitu inaitwa image rights. Image rights ni the ability for a club to market using your image. Okay, of which your pia unasikia mimi nataka 5% of the some good negotiators like Ronaldo unasikia wakisema I want a portion of all markets, wanasema 1% ama 2% of all commercial revenue using my image. Okay, so hata wewe kama msanii kwa pia kwa billboard hiyo ni pesa. Okay, weko kwa chupa hiyo ni pesa. Okay, now sometimes there are some companies that exploit wasanii. Nasikia muziki yako ikichezwa mahali na nataka mkuu ya rada ya special meeting ya elections, nasikia muziki yako inatumika kwa gari inapita hapa, unashindwa kuona gani. So usicelebrate ati nasikika kila mahali. No, you ought to be paid. Nani anakumbuka tu iko sawa? Iko sawa. So pale chuo tu kulikuwa na wasanii wawili. Hii watu ni jenzi. Anajua Jili Majimaji kuna ngoma walikuwa inaitwa Unboga, and it was taken over by hii campaign ya National Rainbow Foundation ama NAC. Hiyo ndio Kibaki, Raila, Ngilu, Kalonzo, Mudi Awori, vijana wa Marwa. It's really captured the soul of the republic. Who can bogo NAC, I am unbogable. And they paid a lot of money for that. Kuna wimbo ingine pia Raila alikuwa anatumia, I think in 2017. Sisi kama ni leo. Hiyo pia walilipa, they had to pay for it. Okay? So in short, ukisikia music yako ikichezwa mahali, hata kama ni kwa radio, you ought to benefit commercially from it. Sawa? And that is why Law Society of Kenya tumeshikana na tunajaribu kuamsha hiyo conversation kuhusu intellectual property, kuleta wasanii pamoja, plant breeders, watu wa trademarks, watu wa innovations kama patents, tunawaleta wote pamoja na tunataka mfikiria outside the box. Mimi nakwambia, if I was president sasa, nimeambia intellectual property, to summarize it, is a creation of the mind. So if I was president sasa, kwa cabinet yangu ningekuwa na minister wa IP who just focusing on IP, because there's so many things. Dawa, you know why China is quite ahead na maneno ya research ya cancer na vitu kama hizo. Let's say a patent ya dawa ni 20 years. Okay. Na hizi dawa unapata ni kampuni tu select ambazo ziko Europe na US huwa zinafanya research. So what China does, at the lapse of the 20 years, they start wanajaribu ku reverse engineer hizo dawa na wanaanza kuzimarket. Once time ya hiyo ndio lapse, wanazirelease kwa market. So there's so many opportunities, creations of the mind that should not limit your mind. Okay, so ukiwa msanii, angalia what more can you do. Sasa hii kuna jaba tu, watu wanachana jaba. Sasa hii unajua kuna jaba juice inauzwa hata kwa supermarkets. Okay, so in short, all I'm saying is that hata wasanii utapata mtu kama Ronaldo, in as much as he's a footballer and he's enjoying revenue from that, he's also a businessman. Yake iko CR7, say anauzanga boxers na others. He's making a lot of money. Hakuna hoteli ambayo inaitwa Restana CR7. All these things are issues that you ought to open your eyes to. So hii topic ya IP, crazy exhaust at aside, but all I wanted to tell you is that there's so many opportunities in IP. Do not just look at small issues, not small issues, just one issue. So angalia tu music, angalia tu how can you also exploit that music. Music yako pia inaweza kuwa part ya play hapa National Theatre, okay? And you ought to also be compensated for that. Campaign, lori ya campaign ikipita hapa, pia hiyo inafaa kuwa unalipwa, okay? Kuna music ambayo utasikia inachezwa kwa ndege, it's part of the playlist ya ndege hapa kwa stadium hapa, anyway, okay? Hapo inakuja vijana wa Kibera watakuwa part of the movie, part of the, I know Kibera will play a big role in AFCON in Kenya, but then again, we will get a compensation for whatever invention or whatever music that you play. Okay? So let's think broader. Usiangalie tu from the lens of music, angalia tu hiyo music yako inaweza chezwa mahali, inaweza chezwa kwingine, and from that you ought to. Okay? Na hizi issues zingine pia, as I told you, we cannot exhaust everything, but these are the opportunities they have, and that is why the Society of Kenya imeamua kutafuta hii. So we'll be having engagements all over the country, all over the republic, hata nje ya Kenya. Kama juzi tulikuwa na World Anti-Counterfeit Day. Anti-Counterfeit Agency ambayo iko hapa Nairobi, it's an organization that looks at the relation of intellectual property. Waienda kwa hapa kwa duka yote kununua kiatu, unaona unanunua hike si Nike ama Puma si Puma. You see such things, these are things that, and you can create your own brand. Okay? Music yako unajiita, let's say unajiita Rodi Chains, ukakuwa na ngeko kuna debo yako, alafu upate mtu mwingine hapo Nairobi chini kuu. Unaona hiyo unakuwa kusudi kama okay. So the long and short of it, IP, look at IP from a broader perspective. Okay? Si issue ya msanii pekee kuimba na kumarket wimbo yako. Hapana, wimbo yako ikichezwa mahali kulia, ipata mahali unakulia, ipafomiwa mahali tu unafaa kulia. Jina yako kama ni brand, endo ni trademark, unakulia pia hiyo. Okay, so thank you so much. As I told you, we cannot exhaust the topic lately, maneno ni nyingi, and that is why we want to do sensitization forums all over the country. Na kwa hayo mengi ama machache ambayo nimesema, ningetaka kuwashukuru sana kwa kunisikiza. Mimi ni Mbogo wa Roy, na mimi ni wakili, nafanya kazi hapa. Najua tutajumuika sana na Felix, na issues za IT. We can now even project them at a national level. Asanteni sana, na poleni, niko na event ambayo inaanza around 11 mpaka. So nikiona si ati siku anataka kuwa na mimi. So nashukuru sana, asanteni sana. Yes. Any question? I'm willing. Yes.
Thank you so much. Last month, I was arrested because I was trying to fight for my rights. So the police told me something, and I said that I was so confident because I knew even if we go to court, I'll win because I'm right. The police told me that for you to win the case, you don't have to be right. You need to have a good lawyer. So this brought me to what you say that you can sue someone. And for me, as I'm a young, still uprising content creator, I still don't have that money to hire a good lawyer. So how can I sue someone like, let's say Gashago is doing a campaign with my song and he has a good lawyer? Am I still convinced that I can win the case?
Thank you. Any other question?
Just want to take, we are having an issue that's going around between my team and the police, starting with rights. I just give a take. And again, I have this project that I'm working on, and so that this company that I have got is called African Art Trust. So they told me to take my money. So I don't know which way forward, which to approach it, and whether maybe would be manipulated.
Feel free.
Mine is a simple question. Sometimes we are creative, we can do work. How do you?
Thank you.
So my question is it possible for you to at least give us a draft of a proper contract to a contract of approach between, let's say, a corporate entity and a small content creator? I believe that there is no small creator or a big one, but depending on the level of experience and work, kuna any possible contract ya kutokana na mkulima mdogo ya kujiconnect na bigger entity na hizo draft content na kuapproach hizo stories za contract, because that's a big problem even to the bigger artists in the country. It's a very big problem. Is it possible for us to have like a session where we can get to brainstorm more about contract approach, signing, and how to follow up?
Correct. Thank you.
Hi. Msento niko na asili
Ndogo.
So I'm a creator who around Kibera, and I usually do 30 second videos about 1 minute. And sometimes unapataga si wale tunabadilishana. Unapata kuna kamoja umefanya imepita 100 G's. So swali ni like unapata obviously yenye imefika more than 100 kgs kupanda. Unapata kuna mtu bado atatumia. No, na huwezi fanya kitu yoyote. And to us here in Kibera, we have some content creators wenye watachukua the exact video waeke logo zao na waiweke kwa mizao. So ise kama mimi naweza fanya aje ndio hii 30 second video yangu isikuwe inatumika without my permission.
Thank you. Achani kwanza nijibu hizo. Oh, thank you.
Kama unasikia swali yako ijajibiwa, we'll take another round of questions. Kama unasikia swali yako ijajibiwa, you make sure you line up.
Sawa. Thank you, Laura. Tuanze na swali yako. Ni kweli, by the way, the biggest problem other than awareness ni kitu inaitwa enforcement. Okay? Unapata yes, unajua ya ukweli rights have been infringed, but hakuna mtu amechukua, siwezi afford wakili wa kufuatilia. So those are the gaps that organization kama hii ama hata human needs project naona tukijaribu to bridge in terms of we want to create more awareness so that people know their rights, but at the same time, if we can, let's say watu kama Law Society of Kenya tunakuanga na kitu ambayo inaitwa litigation support to almost every Kenyan. But most importantly, what I would advise you is by the time, let's say in a contract before even you get to going to court, which will answer some of the questions, is that if you negotiate whatever contract you are negotiating, or you're represented, okay? So sometimes prevention is better than cure. But how you negotiate your contract is as important as how you enforce it. Okay? But uzuri wa copyrights is that any infringement uko na haki ya kununua whether or not you had a contract. Okay? Or no, whether or not you had registered your works. So to answer your question is that equally, that is a big problem that unapata hakuna organizations you cannot afford to advocate to go for your right. But that is where if you approach some of these organizations, I think Felix will be helpful in mapping some of them out so that we work as stakeholders and see how we can push some of these things for artists. However, who launch complaints for Kenya Copyright Board I think it's almost free. There is none. I think it's free. But organizations kama priest patana kama wasanii and you protect your rights kwa sasa wengi. Okay, so those are the issues ningetaka kuangalia. Hata kama wewe ni msanii, are you part of a group of wasanii wengine that have that authority ama wako na hiyo nguvu ya push right yako? Okay, so that is why I would like you to look at that particular aspect instead of you just being as one. Look out for these organizations that wasanii wanashikana and they go for their rights as a whole. Okay, hope I've answered the question.
So again, working individually is a problem, or it's hard because I don't trust people.
it's, you see, these organizations kama AAMP, Kenya Association of Music Producers, in as much as people have complained that even royalties are as one apart from these organizations, but these what they help mostly, especially in enforcement. Juu unapatanga raids zenye zinafanyika kwa umeipata shop inauza tao shop inauza local content, ni ngumu, huwezi pata, and it's because of such organizations. Huwa wanatoka wanaenda na Kikobo officers, wanaanza kuraid. Ukipatikana unacheza music ya Kenya, unauza music ya Kenya na huna any license, any special license from the organization ama the individual himself, your devices are confiscated. So there is that aspect that you should really consider. These music, I'll get their legal name, but there are, and huwa zinasaidia sana kwa hizo issues za enforcement. Okay? And membership ni inakuanga pesa kidogo sana. So in short, what I'm telling you is that prevention is better than cure. Okay. Then tuende kwa swali yako, Majembe versus Obina and image rights. There is a reason why naambianga what lawyers might be expensive. You might cough out some money for purposes of the contractual obligations, meaning kuketi chini na contract. But at the end of the day, hatujui ile contract ilikuwa baina ya Obina na Majembe. So we do not know the fine details were in that contract. So what I'm saying is this, is that before negotiating any contract, have at least a lawyer look at it. Angalia. Ongea na yeye, negotiate na yeye, mwambie niangalie contract, niambie kama iko sawa na kama ni project. Because what some of these national organizations do is that they really exploit young talents. Okay? Napata ile pesa probably ungepata from these organizations sijene alijapata. And given that we are doing probably the same work, yes, we may have more following, more bragging rights, but if at all you do not negotiate your contract as well as you should, then you are exposed, which comes back to what I say, prevention is better than cure. So ensure all your contracts are in order. On your second question, the people who want to exhibit your art, it also goes down to whatever contract that you have with them. Wewe keti chini nao, waambie if whatever revenue they get from exhibiting your contract, you are entitled to a portion of it. So ensure that you negotiate your contracts this way, which means I have answered your question. Now, on your question on if there's a draft contract kati ya wasanii, the long and short of it is that there is no one size fits all. Okay, hakuna, and which is why I would urge Felix ni tukue na let's say mjadiliano, a master class with artists. Unaambiwa these are the things to look out for in your contract, and then whatever you come up with your contract, any information inaweza jaribu to tweak to what makes you. However, all is not lost. Please take advantage of artificial intelligence, AI, ChatGPT, Cloud. These are all these forums, Gemini. These are all these forums. If at all such a contract inakuumiza kama msanii, okay, inaweza kusaidia to some extent, but at the same time have some legal eye look at it, okay, but inakusaidia just to prevent some of these things, okay. Then to answer your question on mtu ambaye anachukua video yako unaipata every platform. Each and every platform. Kama ni YouTube. YouTube hauwezi hata kuweka music kwa background ambayo iko na some of these copyrights. Unapata inakuwa taken down immediately. Okay. So please also normalize. Mimi niwaambia, please protect your art very jealously. Okay. Usione mtu clip yako inaenda viral unasema I'm making it, but there is nothing that is coming to your pocket. Okay. Please be very, very wary of those people. So in short, someone is doing what take advantage of reporting some of these actions. Please report your account in violate my copyright. And the long and short of it is utapata watu kama hao with time, after many reports, accounts not taken down. Okay? So that is what I would advise you. Because each and every platform, whether Facebook, Instagram, YouTube, TikTok, they have a reporting mechanism whereby you can report any content that violates your copyright. And as I told you, you don't have to register your copyright. It exists and it will protect you even 50 years after you're dead. Ni kitu ambayo watoto wako na wajukuu wanaweza kuja. Are we together? So I really hope that I've answered those questions. Zile ambazo sijajibu vizuri ama nitaka further clarification, I think with Felix we can organize something that we can have all artists na waongoze kwa hiyo mada. Kwa sawa? Any other question?
So thank you. Again, my name is Boaz. So my question is, unlike my colleagues, I'm an artist, but I don't sing, I don't do content, but I believe leadership is also an art. So how do I stand to benefit from the program as a person who is passionate about leadership and community development?
Kuna watu ambao hufanya master classes on issues to do with leadership, sometimes even like stand-up comedians. Okay, stand-up comedians, people are actually doing content on issues that really affect the people. Unapata watu wengi wanaenda huko na wako na records like motivational speakers, tunapata wanarekodiwa through your content, they chop it up on Facebook, on Instagram, on any platform, and then they get their revenue from such art. Okay? So it does not have to be music, even a poem, anything. Yeah? These are issues that, and you see nowadays all you need is data. Okay? You only need access to the internet and the phone. That's all. Camera 2 is zero. That's all you need for you to get started on some of these things. Nimesikia kuna mtu kuna YouTube TV station. Anyone with a YouTube channel can come a media house. Okay? And all you need is a Gmail account. So the world is changing and it's up to us to catch up with it. Okay? So we just exploit some of these things.
Just to add something. The good thing now, at least we have Facebook is paying content creators. And it was last week I posted an AI generated picture, and within 5 hours my picture was doing good. I had about $13 within that time, and someone, I don't know, somebody reported my account. I didn't know, maybe we have some people who judge and know that I've done a mistake, but so my picture was bound and my account cannot earn the earnings stopped. So is this reporting of accounts that is what are the policies?
Thank you. For some of these platforms, Facebook, Instagram, YouTube. Once you report account and let's say it's suspended for some time, there are appeal channels. And go directly to you. You can negotiate directly with Facebook so that your account is reinstated. So some of these things are based on the platform that you are. Because what you get from Instagram, the appeal process in Instagram is different from, let's say, TikTok or YouTube, who are owned by different entities. But what I know for sure is that each and every violation there is a remedy that can do. For example, you can suspend this and appeals process. Some of these things are way above our pay grade because it now depends on how we negotiate with some of these platforms individually.
But I think the platforms are managed by AI because when Onana was playing for Manchester, the fans of Manchester decided to report Onana that he's literally a goalkeeper. And his account was banned. So if these are people managing the accounts, then
No, the account is banned. I think the account was later reinstated.
but now for me I'm not earning and I'm depending on it.
As I told you, there are some appeals processes that you ought to find out from that particular, and that is why we need artists in that class. And let me tell you that is also something that I've noted from these organizations, these music organizations. They also have classes on how to manage some of these things, and you get some expertise from just belonging to some of these organizations. So that's why I'm telling you, be proactive. Usione kwa hivyo ukikaa solo utaumizwa. There is strength in associating yourself with something that benefits you. Yes. Yeah.
So mimi walisema is Meta I guess na Facebook, Instagram, right? So they had said there's this time they said because we have so many creators and content creators, we get creative, and then there's this point when they come there that any AI generated content zitakuwa pulled or not monetized again. So if you find in your account maybe put down or banned or not monetized again, it's because maybe you was uploading too much of AI generated content. And remember, we are white block, we are so communicative, right? The same thing is thinking is high, and then if we are all competing to like generating income and you're using AI too much, it means we that we're not using AI are not given that platform to get our works out there vizuri na maybe jasho yetu is not like recognized. You get with AI, it's just a prompt where you write and then you get your stuff out, right? So Meta walisema if your content is more of AI wanaitaka, it's not monetized even if your account is monetized. So if you see your account continue, it means you like go back to the field, usitengeneze content kwa nyumba. I'm not sure.
Thank you. You see the advantage of knowing other people. You get to learn a lot from your peers. Yes.
So I have one question. Let's say nimepata investor anataka put money into my music. So how do I separate the investments from ownership of my music?
How do you?
Separate investments from na ownership ya IP yangu.
How do you separate your investment from the ownership of your IP? What is this investing in?
Like he's putting money for you to, let's say, shoot videos, record music, kutafutia tu beats.
I know. So that question is simple, and its answer is also simple. What have you negotiated with this investor? Okay. unapatanga wengine wanataka kutumia for your voice, for your image, for everything that you have, but you're not getting value for your money. Okay, that is why I'm saying, please separate your personal feelings, because music is very personal. Unapatanga unasikia vizuri ukisikia music yako inachezwa mahali, but at the end of the day, look at it from a commercial perspective. What am I getting from my music playing? Kuna wasanii wengi husema nilikuwa na trend Kenya mzima but hakuna kitu nilipata. So it goes to that particular issue. Felix, I think you need to have a masterclass on how artists can negotiate contracts and get value for their contracts. And remember, there's so many things you can do. Nimekwambia unajiita Robbie Chains. Ukisikia mtu anajiita, have you registered Robbie Chains as a trademark? Please consider it. Okay, so that ukapata mtu wako na t-shirt imeandikwa Robbie Chains na logo yako. How did they get that t-shirt? Okay, so there's so many things. After Safaricom advertise na, let's say, your name ama your music, you ought to get compensated. Skiza tune when you compensate watu for each and every thing, for each and every ringback unasikia. So in short, the opportunities to make money are limitless. It's only about how you take advantage of them. Yes. I really hope nimejibu maswali kwenye inafaa. Some of these other questions, we have a follow-up session with Felix tuone venye tutasaidiana. But long and short of it, asanteni sana kwa kunisikiza. I hope I was very beneficial to you, and I look forward to meeting with you at some other point. Na kwa haya mengi na machache ambayo nimesema, asanteni sana.
Situpe mgeni makofi. I think swali moja ambalo mlikuwa mnauliza ni kwamba gharama ya ku contract lawyer ni pesa mingi. Ni kweli? Ni pesa mingi, but art ya lawyer ni nini? The art ama earning ability ya lawyer ni nini? Ni hiyo kazi yenye unafaa kumpea ndio afanye nini? Ndio apate pesa. Si ni kweli? Now I want to ask you a question in the sense that is it something that ulienda kwa lawyer ukapata ni expensive, ama ulisikia lawyers ni expensive na wewe ukachukua hiyo story kwamba lawyers ni expensive na ukabeba hiyo ukakimbia nayo? Which is which? Ulisikia tu, si ni kweli? Yeah? And then you remember that person in there's an MP in Tanzania. Aliuliza ulisikia wapi? Ni kweli? So kama ulisikia na huyo lawyer haujamuongelesha, hiyo shughuli yako hata ako willing kukufanyia kazi for free, but haujajieleza. So how would you know then that this lawyer is expensive? Saa zingine tunasema Mercedes ni expensive, but hujaenda ulize ni pesa ngapi. Maybe as an artist umewin ukapata 1.2 billion, yeah? But kuna Mercedes mahali fulani inauzwa 800,000. Bora tu iko na hiyo logo, si Mercedes. Whether mzee ama mpya, hiyo ni nini? Ni Mercedes. Hata wewe ukienda na screen unasema hii ni German what? Machine. So at that point, what I can say is that let's not say that lawyers are expensive. Kwa sababu today we are taking part of their trade by listening to what they are telling us, by listening to what they are informing us. Now, you can go to a lawyer and you find, yes, ni more expensive. Alafu akwambie, I will do for you this contract. But, kuna shughuli huku na kuanga nayo ya kudeliver mabarua kwa maofisi, serving clients. Akwambie utakufanyia hiyo shughuli, na wewe for 1 month, you will work for me, delivering these letters for my clients. Hapo si utakuwa ume-earn. Na uki-earn hiyo pesa si utalipa huyo lawyer. Na ubaki na change. Yeah, so I think let's not look at it like lawyers are expensive. They are not. It is only that you've not gone to them and done what? There is one thing that you have to do, and done what? Talked to them and negotiated. Contracts are negotiated. You negotiate a contract. Even what we're actually talking about art or artists, you are actually asking a question that if I am signing a contract with a specific media house, how am I going to structure my contract? For a contract, kuna two parties. There is one party that is giving a service, and there is the other party that is receiving a service. In between, kuna mmoja atapokea pesa. Na ule mwenye anapeana pesa atakuwa amepoteza nini? Pesa. But vile amepoteza pesa, amepata nini? Amepata service. So it is a give and take situation. So through that, we're able to learn how we are able to structure our contracts, and that is why we are actually working together. And today we have the pleasure of having a representative from the Law Society of Kenya, specifically touching on intellectual property. How many of us know how wide the Law Society of Kenya is? It is everywhere. It is lawyers everywhere in Kenya. It is the body that regulates lawyers. It is the body that gives lawyers the practicing certificate each year. They pay something for them to trade within that particular year. And through that, we're able now to get an opportunity to speak to them directly. And through that, they are able to also get to learn our plight, our challenges. And you know, by knowing them, you can go and say, Bwana Wambugu, I have this problem. How can you help me? He might not represent you in the courts, but him just sharing and saying, I think this could be your problem, you could be able to find help here and there. Or maybe I can guide you on how to go about this. Soon we're actually building a legal clinic here at the Human Needs Project, where all this information will be available. And we are, you know, ensuring that we are able to live to Article 48, which says access to what? Access to justice. That you can be able to get information that can be able to help you and, you know, navigate around the murky waters that you find and be able to find a solution to your problem. Now, I know Mr. Wambugu will be leaving shortly, and we will also be able, if you have questions, we have our WhatsApp group where we have created. Please bring them as often as possible, and then we can also, at some point, because meetings sometimes could be expensive, if maybe, for example, Mr. Wambugu could be using from where he used to come to here, we can utilize an online platform, which could be a Google Meet, it could be a Zoom with our phones and with our laptops. We can go into that and say, we just need you help, 30 minutes, 40 minutes, and he's able to support us. So at that point, I want to welcome Vanessa, who is going to now lead us through the program. And listen carefully. This is now where you're going to interact with every issue that already Wambugu has talked about, Yvonne has already talked about. Listen carefully so that at the end of the session, you can also ask questions. If you're able not to remember, just type it even on our WhatsApp group. Through that, you can be able to remember so that when that time comes, you basically come and ask.
Hi, how are you guys doing? Thank you so much, Felix and team. I'm really happy to be here. And I'm glad that Wambugu has set the pace, because I think most of the questions you've asked you preempted what I'm about to present on. So I hope we'll be able to move together. If I'm going too fast, feel free to just slow me down. If you have any questions, just write them down and then we will deal with them at the end. Sawa? Hata mimi, I will try to mix languages and dumb this down as much as possible ndio tuelewane. So we'll start from the very basic levels of what IPs are, how they come about, how you can identify the kind of IP in an artwork or in a creative work, and we'll move down to, you know, what to do to safeguard your rights, how to negotiate contracts. I've heard there are some content creators, we're going to go into that. We're also going to go into then if there's an infringement and someone has used your work without your permission, what are you supposed to do? So that's a summary of what we're going to discuss today, but I'll take it up from slide 3, which is just, let's understand IPs zilitoka wapi, why we are so concerned, why everyone now is talking about IP and protecting your IP and registering your IP. Basically, IP is, as Wambogo had told us, just work, creative work, like something that you create from your mind. You sit down, you think of a poem or a rap, or as a photographer, you have like this concept. It's in your head at that point, but then there's a way you can remove it from your head and bring it to life. That is your intellectual property. And it can take so many forms, which you're going to go into. But I think most importantly is the point that we are at a juncture where everyone is creating something, you know. Either you're an artist or you have some music or a poem, or you even think of creating something like this for filtering water or something. Like everyone has an idea, and the state is aware that people are so involved in creativity to a point that they're thinking, what can we do to promote this creative work, but again ensure that these people are motivated enough to create works. And so you find that the Constitution is like a core champion for IP. You find in Article 11, the Constitution recognizes that cultural heritage can be expressed through intellectual property. If you go to Article 40, you find that intellectual property is now being recognized as property, like land or a car. Just the way you can own any other property, intellectual property is also property under the Constitution. Then you go to 259, you find that the definition of property has so many things. Alafu kuchini says including intellectual property. So I think we're very clear on the fact that the law is now very cognizant of the fact that IP is also property. And I think to make it even more intriguing is the fact that you can even use your IP to get a loan. You know, you don't need a logbook or a title deed. As long as you have a certificate and it can be valued. So let's say you register your IP, you get a certificate. If you can value your IP, you can use it to get a facility from a bank. So, and there's an act to that effect, an act of parliament. So we are going to a place where gradually it's going to be a big thing. I know Amboko called it an emerging area, but I know it's going to really blow up very soon, and that's why it's very important to have these conversations. IP imetoa watu block. Mtu mwenye never imagined like even being approached by a certain brand, you just shtukia there and email is, a brand is approaching you to advertise on their behalf or something like that. So, or like to use your music in advertisement. So I think we are at a point where we can't avoid the conversation, and that's why we are here today. So that's an overview of, you know, what IPs are, what is the legal underpinning. So we also have, apart from the Constitution, we also have like other acts of parliament for various IPs. We'll go into that shortly. Then we also have the relevance and the importance, which I said there's need for you to feel incentivized to create, so that you feel like, yeah, I'll produce this work and I know for sure that are protected under the law, and I can make money out of it, and I can sue if someone tries to joke with my work. And then there's categories and ownership. So for categories, we're going to go one by one because there are quite a number, and I'll try as much as possible to simplify so that we can all understand. Then ownership, of course, as we've seen, corporates can own IP, you can own IP, I can own IP, you and I together, we can co-author a song and own the IP's rights to that song. And then we have commissioners. So commissioners are like what you call someone who pays you to do the job. So let's say you've been contracted by a brand and they tell you, come, we have an event, we need you to take photographs of that event. Like these guys have made me sign away my iPad just right now because they've given me a form and they've told me we are going to take photos of you as you speak to these people, and then you have to indemnify us and tell us if we post these photos on our platform. If I see my photograph tomorrow on their IG, I can't sue them. I've signed my rights away. So if a commissioner is someone like that who tells you or who calls you and tells you take photographs, now these photos are mine. So I'll pay you for your service, but you can't come later and say I took those photos, I want them. Or in a setup of like an employment context, when you umeandikwa kazi, you find that you generate a lot of documents for your employer, and at the end of it all, you can't say, send me that PDF, it's my property. It's your employer's property at that point. And what we see that the law is very clear. As we all say, it's not clear, but for copyright at least, the law is very particular. It says, for any commissioned work, for anyone who pays you to create work, they own it. Until and unless you agree otherwise. So until we have a contract saying, fine, you paid me to create this work, but this contract, this clause says, the IP remains with who? With me. So until we have such a clause, by default, any commissioned work, any works you're being paid to do for someone, is theirs. That's how. So we're gonna go a bit more into that. Yeah, so that's just an overview. So I think we'll start with the hottest topic, and I think an IP that resonates with many of us. We do it every day, even if we don't know we do it, and it's copyrights. And I think the most intriguing thing about copyrights is that you don't need to register it. By virtue of it having come to life, for lack of a better term, the ownership rights like crystallize for you. So, what are copyrights? Think literary works. Literary works are all this: your novels, your poems, your plays, your stories, your scripts. Kain msanii, you usually have I don't know how you do it, but I know you write your lyrics down, whatever, that script. Think of artistic works, think of the photographs, think of the paintings, engravings, works of architecture. Then you go to musical works. So the kind of music you produce, the kind of music your lyrics, translating it into an audio or an audiovisual material, right? Think of dramatic works, so that are films, plays, and the like. All that, you have copyrights vesting in that kind of work. Then, this is the thing with copyright people don't know. Copyrights, just because I have an idea and I have this song I want to sing or this poem I want to write down in my head, doesn't mean that at that point of thinking about it, it's my copyright. Because copyright only crystallizes when one, the idea is original, so no one else has it up there, no one else has already come up with this poem or this song or this artwork. It's original. And two, it's been affixed in some kind of medium. It's not some kind of thought in your head, it's not an idea. Because this is the thing, I might come to you and tell you, hey, Nikon idea kali sana, I want to produce this song and these are my lyrics. I'm telling you. But at that point I'm telling you, I have not actually reduced anything. I don't have a script, I don't have a video, I don't have an audio. At that point, for so long as I have not reduced this thing into something tangible, something I can hear, I can see, I can touch, then copyright doesn't vest. So the first two things you should know is that work should be original. And two, you have to reduce it into something tangible. So that it's not just your idea, but it's your idea having been expressed in something. At that point, your copyright crystallizes, whether you register it or not. Sawa. But we are pro-registration. This is why. Assuming you're my friend, for example, we're friends. I come and tell you, hey, I have this idea, brilliant. I have this business plan. I want to start a business, At that point, I'm telling you, I don't have a business plan reduced into writing or anything like that. You take it, you run with it. You go, you start the same business. Then now we're in court. The problem with that is it's a he said, she said situation. So I'll have to tell court, look, this was my idea. I told this guy last year in December, I want to start a business. But you see, a court is a court of law and a court of evidence. Who has it in writing? Who has the business plan? Is it not him? So who will the court listen to? Is it not him? But the moment I have a certificate saying, look, my copyright was registered in December last year. Around the same time I had this business idea and I have this business plan that my copyrights are attached to. And I tell court, here it is. So this guy, he's done with my business, with my idea, he's doing the same thing, he stole it from me. The court is more likely to be persuaded by my side of the story than his side of the story. So yeah, fine, you don't need to register copyright, but we highly encourage you to register it, especially because now Kekobo, which is like the overseeing body, has made it so easy for everyone. You can do it online in a snap of a finger, and I think for individuals you just need about 1,000 bob to 1,500 to register your copyright. So I think they've really made it accessible, and I don't think there's any reason for anyone to just sit on it just because the law, says you don't need to register it. So in as much as you don't need to, we highly encourage artists, painters, photographers to actually register copyrights to their work. So up to there, is the speed okay or we're going too fast? It's fine, perfect. Aya, the next thing we're going to move to is we've registered our copyright. What kind of rights then do you have? Now you have a certificate, you created the works and you can show it, you can show it's original, you can show it's been affixed to something. What kind of rights do you have? So for copyright you have two main rights, and they are categorized into one, your moral rights, and two, your economic rights. Your moral rights, it's like they're attached to you till death, do you part. You cannot assign them during your lifetime, and they only transfer to your estate when you die. Your moral rights are like your right to be recognized, to be credited for that work. It's your work. Your right to object to any mutilation of your work, to any distortion of your work. So a good example is when you have a song, for example, and your song has a tune and a beat to it, and that's what makes people vibe to your song, and that's what makes your song trend. Then you find someone has put it into some alternate AI thing, and now your song sounds off. It's completely dissociated from you as an artist. That is mutilation of your work. That is a violation of now your moral right, because you have a moral right to object to your work being distorted in any way. Then now we have your economic rights. Now the economic rights are what we are all talking about. The right to produce your work, to copy, to share, to distribute. If you have an artwork, the right to reproduce that art, sell it to someone else, the right to make copies of your book, for example, if you're an author, such rights. So such rights are economic rights, and those are the rights that you can now transfer during your lifetime. So you can assign them away, either through licensing agreements or assignment agreements. We'll go into that and what they mean. But essentially, those are the two main rights that now have come to you as an author of a copyright work. Up to there, we're good. Perfect. Now, next slide. Let's go to the next slide. I think Wambogo touched on it a bit, but the beauty about registering copyrights is that the right subsists over such a long period of time. For things like literary works, we talked about them, the books, the poems. These rights, they last 50 years, for 50 years from the day you register them. So let's say you register them today. They will last 50 years from today. And then, so they will last during your lifetime. So let's say I register them today and then I die next year or next year but one, not on wood. Those copyrights subsist till I die and then plus some 50 more years. That's a long time to take advantage of whatever IP you've registered under this category. The next one is this audiovisual works and the likes, applications, Now these ones, they still have a long lifespan because it's like 50 years from the date of creation. They don't attach to your lifespan, but insofar as you created them or like you registered them today, they're going to last for like some 50 good years. That's a long time to live them, to earn off such an IP. And then after the expiry now, the work falls in public domain and anyone can now use it. So then I think the other part is like the people who are now associated with such copyrights are like performers. People who like, maybe if you're a performing artist, you have like they call them backup singers and the like. Those are performers. You have producers and sound recorders, people who you go to the studio to collaborate with. You also have these broadcasting channels, maybe the NTVs and the KCBs. They have like created rights. They don't own your copyrights, but they also have some sort of protection because they helped or they contributed to producing that work. So yeah, that's that. So that's copyrights, and I think that's a very simplified version of what they are. And I think the next thing we should look at is then what are the best practices? How can you safeguard your copyrights after registering them, or how can you ensure that you're protecting the kind of work you have produced? The first thing is leveraging on copyright licensing and granting permission to use the works. I'll dumb it down. Someone talked about an organization approaching them and asking them for art. It was you or you. Now we've established that the art is copyright. That we're not disputing. And by virtue of you creating it, you have copyrights. You don't need to register it per se. So as we speak, you own copyrights to that artwork. If they call you to the table and say, look, we want to use this art for whatever reason, but that whatever reason is going to make them money, they're going to call you to the table and say, let's negotiate how we're going to use your artwork. The first thing you should know is that that conversation can go two ways. It can either go the first way, which is, I will license my copyright to you. And licensing basically means nitakupea utumie for a short period of time within a defined area, whether it's within Kenya or within just Instagram. The geographical indication can be country-wise or it can be platform-wise, yeah? And you're going to say, for that period, because you'll be making money, you're going to pay me a percentage of it. What we're calling royalties. You get? And so, it is also very important to make sure that in that agreement, what you're calling a licensing agreement, it is very clear that your copyrights have been licensed and not assigned. Because when you assign, you're giving it away forever. It's going to be theirs and you can't do anything about it to get it back in the future. So it has to be, there's a very clear distinction. That contract has to make a very clear distinction that this is a licensing contract for an X period of time, and for that purpose, you're going to pay me X percentage of what you get from whatever you're going to do with my artwork, and then I've given it to you. Nisisikie third party company ingine umeilicensea unless you're comfortable with that. Again, goes back to negotiation. So you have to be very careful with the terms which you agree your work to be used. If it's a photograph, a brand has approached you, advertise this for us, take a photo with it, make a reel with it. This reel, we have to be very clear. Who is going to be using it? It's you. That means I should not be seeing it in someone else's platform. That's one. Number two, for how long are you going to be using this reel? For 2 months. Fine, you can do 2 months. Number three, which platform is this? Instagram. So if I see it on Facebook, it's a breach, isn't it? Number four, if you're going to be paying me for this work that I'm going to create, one, what are the payment terms? Are you going to be paying me per engagement, per number of views? And if it's number of views, then how much money can 1K views make me from this particular reel? If it's on my Instagram page for 2 months, how are you going to gauge how many views do you want in 2 months, and in that regard, how much are you willing to put on the table? After the 2 months, I'm allowed to pull it down. Because what you realize, what brands do is they make you contract for a particular period, but they leave what you're calling they leave a surviving clause there. And then they say, when this contract lapses, that video should still stay on your platform for whatever timeline. And that is a clause a lawyer can easily identify. Where kama msanii ama where kama content creator, you will not see it because there's a way they frame it. You will not see that's what they're trying to do. But if a lawyer has a look at your content, they're able to identify that clause immediately. These are the kind of things you should be looking into. If tumeingia kwa a contractual agreement, let's say I shoot a reel for you. You send the first one back. You say it doesn't meet our specifications. Repeat. I do the second one. You send it back. You say bado. I repeat. The agreement has to be very clear that the payment you're going to be paying me is for one reel. But should you require me to do another reel or a repeat or whatever I do, then these payment terms also apply. Then there's what we call a kill fee. A kill fee is where a brand has given you work, you do the work, you send, then suddenly they send an email and tell you, thank you for sending, but now our campaign is over, so I think we won't be proceeding with this contract. It's very likely that you find brands that are willing to cut your contract halfway just because of something has happened internally, like in the organization. You have to have a kill fee. And a kill fee is like, think of it like a non-refundable deposit that says, for as long as I've completed the work, you pay me 50%, let's say 50%. Before that tuanze kazi. So that in any event, if you terminate my contract katikati, before the whole thing crystallizes, then what that means is that at least I've secured some money from you. But creators don't do that. So I think I've gone off the tangent, but that's basically what this first point is. It's ensuring that as you negotiate, as you're trying to make money off your talent, you are very sure that the kind of contract you're negotiating is the right kind of contract. It's a licensing, not an assignment, or vice versa. You have to ensure that for authors now, for example, who write books and the like, you can leverage this. When you put this small cassie with a circle, it means that that work is copyrighted. And whoever that is going to reproduce it, sell it, distribute it, without your consent is basically infringing your rights, and you have actionable remedies which we'll go into. And then you have this terms of use section. So for those guys who have websites, maybe you have a website and in that website you have, what are you displaying? Let's say you have videos, or you make videos and you post on your website. You need to make sure that, I'm not an IT person, but I know for sure that I see a lot of these click-wrap contracts on websites. So you go to a website, then the first thing that pops up is terms and conditions, and then they tell you accept. So you can't access that website before you accept the terms and conditions. Or let's say you're downloading an app, a mobile app. A mobile app has IP. So whoever creates a mobile app has two IP rights. Has copyrights on the source code, and also has a patent rights on the usability of that particular app. So when you download an app, the first thing that pops up is terms and conditions. You have to accept before you move forward. Now in those terms and conditions, you have to take advantage of those terms and conditions and put there detailing how your work should be used, what you won't accept your work to be used for, what you won't accept your work to be done to, that is mutilation, masturbation, and the like. So everything that you want, you put it in those terms and conditions. So whoever is on your website, before they even proceed, they have to accept, and under law, that's a binding contract. You guys who usually go on random websites and you just accept in terms and conditions, then they produce that in court, you know that that constitutes a binding contract. So for creatives or people who have like IP interests, that is a very good point to take advantage of. Then of course you have to keep records. So if people don't do this a lot because of course we don't anticipate Mashida's it okay, but usually if you're creating something, it's very important for you at the point of creating it to record, this is the day I did it. Because when issues come up later and the court is requiring you to prove that you're the first person who came up with this work, it's going to be very important to demonstrate that this is the particular date that this work actually came to life from you and not someone else. Then there's this digital rights management, the DRMs. I think this will answer. There's a question I had someone saying, you see your video is trending, it blew up, it's trending, everyone is using it. What can you do about it? I know Onbogo answered it very well, but also you can take advantage of what you're calling the digital rights management technologies. So this includes things like watermarks. You watermark your content. So if it's a video, you ensure that if it's your logo or whatever that you use to, something we can use to identify you with, or something we can use to relate your work back to you. If it's a logo, just watermark it there on your video. You see, wherever it goes, it has that watermark, whatever it is. So whoever is using it, it will be very clear that it's on your page, let's say Kimani 123, but the logo is Wambogo 123. So obviously, the person who is uploading this in the Kimani page is obviously in violation of an IP right, which is a copyright. So you can take advantage of that. Then you can take advantage of monitoring use and flagging misuse. I think for this one, platforms have helped creators a lot because a platform like TikTok will tell you your content is being downloaded like this many times by this particular page, and it allows you to also report if you feel like, this person who's downloading my work is using it for the wrong reasons, or like is using it to commercialize, and I'm not agreed to it. Then there's things like encrypting your work. So if for example you have like a business idea or a trade secret, let's say umeanzisha hoteli hapa Kibera, and your hotel is making something very unique, let's say a particular snack, a particular food that has come about from like a very special recipe. That recipe, of course, you have it down somewhere, you have it down in writing. By virtue of that, there's copyright there. So what you can do is you can encrypt that document. If it's in soft copy, of course if it's in hard copy you can put in a save or whatever, but I think we're going digital and most of these things are like soft copies. So you can encrypt that soft copy so that you can only access it by inputting a particular code or a particular password, something like that. I think that is a very proactive way of using this DRM technologies. So those are some of the best practices you can employ when you're trying to protect your copyright. I think we can move to the next one, which is trademark. So I'll put a pause on copyright right there. And I hope the speed is okay. I hope we're together mpaka hapo. I've dumbed it down as much as possible. I don't bombard you with the legal terms or whatever. So nimetoa anything that would make this not digestible. So I think up to there we can put a pause on copyright. We'll come back to it at the very end. Let's move to trademarks. And I think the best example for trademarks is, I think he stepped out, but what was his brand name? Rolly Chicks. Yeah, and I think for most, let's say, utaipata kwa kofia, ama utaipata kwa shati or whatever. That is a trademark. So a trademark is just like, it's any sign or logo. Other sign, my name is Vanessa Sifunde. If I want to create a logo of my names, whatever, that sign, that logo, that is a trademark. It's a mark just from their name. And what it's meant to do is it's meant to distinguish your goods and services. It's what makes you buy Tuzo and not Brookside. It's what makes you buy X and not Jogo. That's just the simplest way to put it. It helps brands and companies distinguish themselves from their competitors. And that's why we take it very seriously in law as lawyers. If our clients come and tell us, hey, there's this person, I see they're trying to, if my brand is Nike and they're selling Nike, it's the same shoe, it looks like the same shoe, just a slight difference in the name, there's a breach there. And sometimes you find that you haven't registered your trademark, so like you didn't register your trademark, but it doesn't mean that if you find someone misusing that trademark, he still doesn't have a revenue. Or should be discussing about your brand. So we're saying, in any event, even if he hasn't registered his trademark, doesn't preclude you from still taking an action, because trademarks, you can still sue on this premise called a sort of passing off. Passing off is basically someone else is pretending to use your name because they know maybe your name has traction or people know your brand. So if they try to look like your brand, people will buy, and that's like a violation. So that's trademarks for you. So trademarks, you can register them and keep it. They're slightly more expensive than copyrights, because for copyrights they're like 1,500 and 1,000. For trademarks, they're like between 10 to 15,000, depending on the kind of trademark you want to register. And then for trademarks, the process is slightly longer, because the first thing you need to do is to do a search. So you have to ensure that the mark you're trying to register, or the name or the logo, doesn't exist. So it can't be that someone else is using the same logo or something similar. The registrar of trademarks won't accept that. Your name can't be descriptive. Let's say you're selling juice and you want to come up with a logo, to trademark a logo for your juices. Your logo can't be sweet. You know, sweet describes juice. So your logo can't be descriptive of what you're selling. Your logo can't be against public policy or morality. So it can be something that if we read, doesn't sit well in society. Something too overtly sexual or something like that. It would be very immediately. So that's for trademarks. I think the thing has gone off. I can just pick up with my phone as we wait for the thing to be fixed.
You can use this.
Okay, perfect. Yeah. It's fine. Oh, it's connected.
Yeah.
Yeah. Yeah, so that's that. And I think the most important thing to highlight is the fact that just because you've trademarked your logo doesn't mean now you don't register your business. Those are two distinct things. If you have a business, you have to register your business name. So for example, if my business, I used to have when I was in campus, I used to sell smoothies to my peers. I used to have a business called Nessa Smoothies. See, I can trademark that name or that logo. I had a nice Kaelo logo. I can trademark it. But at the same time, I still need to register my business name at the business registry. So you have to do both. So one does not replace the other. So you have to do both. And then I think thought about what can make your suggestive name or logo be registered. You said it can't be identical to any other in the market or close to any other in the market. The immediate suspicion would be like you're trying to pass off. It can't be descriptive. You can't trademark the word sweet because you're selling something that's sweet. You can't. It can't be a generic term. Like for example, trademarking chair, the name chair, because you're selling chairs. So that will be, you have to be very creative when you're looking for a logo or a name. And then I think the most important thing is just because you've registered your trademark here in Kenya doesn't mean someone can't abuse it outside of Kenya. You see, IPs are territorial, so your IP is protected here in Kenya. If you want to expand, such your IP is protected like beyond our borders, you have to either individually register your IP in those particular jurisdictions, those countries, or like for trademarks, Kenya is part of like a treaty called the Madrid Treaty. The Madrid Treaty has like 70 countries. If you register your trademark under the Madrid Treaty, then one registration will cover you in 70 countries. I don't know if it makes sense. Yeah. So if you're how we make it, you want to go international, you want to protect your mark. If you're so popular, there's a very high likelihood that your logo will be used somewhere in America, somewhere in the UK, and you're very suspicious, you can now register your trademark internationally if you so wish. So that's that. I think you can go to best practices when you're dealing with the trademark. So you have a logo, you have a name, you have a, it can even be a combination of colors. You can take yellow and green and you come up with a very creative color. You can trademark that. I think a good example is Airtel. Airtel have they have a, if you see there's a color, if you see a certain color, you can tell this is an Airtel color, the red. You know, so I mean that the red is it's not the usual red color. Maybe it's a combination of different things. Where I work, for example, we have a company, we have a color that we mix several colors to come up with a very special color where we use in our documents and everything. We can trademark that. So yeah, that's trademark. So the best practices are, one, we said for copyrights, you can use that kasi and a circle in your work. For trademarks, you can use an R and a circle. I think we'll see it here. But just an R and a circle just next to your logo. That will give it legitimacy. Will give it. It shows that it's been someone owns trademark to that particular logo. So there's that. Number two is keep a record of everything you're trademarking. Because trademarks can be so many things. It can be a logo, it can be a name, it can be a sign, it can even be your signature, it can be a color. So if you have many trademarks, you need to keep a record, because the thing with trademarks is after 10 years you need to renew. So if you don't renew within the 10-year mark, it lapses, your rights lapse. So it's important to keep track, or to have your lawyer keep track, so that you renew on time, you ensure that everything is in order, and that your rights are perpetually protected. So as long as you renew every 10 years, you're good and you're covered. I think I can just use the laptop, it's fine. I don't mind. Okay, but it's not. Yeah, and consider costs. Trademarks are also a bit slightly expensive. They're like 15 Gs. But it's worth it. It's like 15 Gs for 10 years. So it's something you can definitely think about. And then, yeah, capitalize your market. This is the symbol I was talking about. This one right here. So if this one is next to your logo, I know definitely there's a trademark there. So those are some of the best practices you can use for that. If I put a pause at trademarks, there. We'll come back to it in case we need to. But it's one of the most simplistic IPs, really, because there's nothing much to it, and it's very easy to register. I think we can now move to patents. Patents, I usually call them IPs for some kind of geniuses or something, because this is where now you find people who like create state-of-art things that you've never seen before, that change how things are done. Patents. Patents, you think of patents, think of inventions. Think of something that has shaken the market, something that has never been seen before. So the reason why we don't hear a lot about patents is because the threshold is so high. For you to register a patent, you have to show 3 things, which are very difficult to show. The first one is that it's new. So this invention of yours, let's say you the first person to ever come up with the idea of a chair. The chair, it has to be new. Like there's nothing like it ever globally. I'm not talking about Kenya. Like no one in the Middle East, no one in the UK, no one in the US has ever thought about something like that. So it's new. Number 2, it has an inventive step. Inventive step means, let's say I'm a lawyer. No, I think the better example is like I'm a doctor. I'm a doctor, and I've come up with a vaccine, and I want to patent that vaccine, because if I sell it to people like the COVID times, people who made like the Pfizer's and those COVID vaccines, they made so much money. People patented that particular vaccine. Inventive step means I have to show that no other doctor in the world could have thought about coming up with that vaccine. So it basically means that no professional in whatever area you're trying to create or come up with an invention could have ever possibly thought of coming up with anything like that. That's a very high threshold. And the third one, of course, is it has to be industrially acceptable. It has to be useful. Like it has to solve something. It has to solve an equation or a problem. So for this one, the threshold is quite high. When we usually get like most people who come up with like new inventions, they fail on this step, this inventive. But it has to have an inventive step because they can't show how someone in that industry could have never thought about something. It's a very high threshold to hold someone, or a standard to hold someone to. And so because it's a very high threshold, people don't patent most of their inventions. They do something else, which is the next thing, which is the next IP. This is too high for most people, unless like you're some kind of genius and all of that. But it can, if you come up with something creative, something new, something that no one in the world has ever come up with, or something that no one in that industry could have ever thought of, you can register your patent with Kipi. And when you register your patent with Kipi, I've said it's like for 15 Gs to register it. And if you want it here in Kenya, that's fine. But if you want to go international, as I've said, you have to register it under an international scheme. And for patent, it's this patent, it's this treaty. So you register it under this treaty. And effectively, all the countries under this treaty, about 50 or 60, you will protect your work in all those countries. But now, because this is too high, we don't talk about it so much. We talk about the alternatives. So you have a creation or an invention. You can't patent it. You can do something else with it. So let's move to the next slide. Utility models and industrial design. These are like mini patents. These are like I couldn't meet the patent threshold, but I can meet the utility model threshold. I can meet the industrial design threshold. So utility model is basically you protect the utility of something. So you see, for patent, we said you have to show that this thing is useful. This thing is solving something. So now, because patent has 3 steps that you can't meet, at least you can meet one, meaning you can show the utility of this thing you've come up with. You register it under a utility model. So then there's also industrial design. Industrial design is like, it covers like the aesthetic of something, the shape. So like let's say we are used to bottles being this shape, but then somewhere in your creative mind you come up with a very unique shape no one has ever seen before, and it's like a very nicely shaped bottle. You can protect it under utility model design. Or these people who have like these Maasai people who come up with very nice earrings, ornaments, or like very nice Ankara prints like this one. Like this one, if the creator is alert, she probably has it registered under an industrial design. So that no, if she sees this somewhere else, there's a problem. She sees the same design. And I think the people who do it a lot are Nigerians, because Nigerians are very big on Ankaras and all of that, and design and fashion and all of that. So think of these are like mini patterns, like you have something that's creative, something that is useful, something that's new, but you can't meet the patent threshold. You can register it here. A good example is this ceramic jiko. This one that used to trend like we were a bit younger. It was like brown and it had a very unique shape. That was actually registered under utility model, but it expired sometime 5 years, 10 years ago. So that's like a dumbed down version of what these are for UMs and patents and industrial designs. Then the next one is trade secrets. Now this one is just what I was telling you about, that you have a business, let's say, and your business, let's say KFC. Who knows the KFC recipe? I've tried it in my house, it has never worked. Like, I can't seem to just get it right. And that is because in all its franchises all around the world, they've made every single franchise and their employees all around the world where they are located to sign NDAs. NDAs that bind them post termination of their employment. So even if I work at KFC today, I'm going to, if I get a job, let's say as a cook, they are going to have to train me on their recipe because they have a standard of how their chicken tastes all over. If you go to KFC, Maju should taste the same. That's why it's a franchise. So they have to train their staff the same way across all the countries. So of course I'm going to be exposed to your trade secrets because I know, hey, this sauce that you make, that you give the chicken is made like this. They have to make them sign NDAs so that even if they're fired or they leave employment, they still can't go to Chicken Inn and reveal that particular trade secret. So trade secrets are not protected like at eBay, you can register copyrights or trademarks or whatever. But most people protect their trade secrets through NDAs. And if you break that NDA, then you're sued. And most of the time, people who have these NDAs are big corporations who have something to lose. If this thing goes out, their competitors are having them for breakfast. And that's why they're very keen to ensure that they put it in a separate NDA and still put it in the employment contract so that all grounds are covered. So if you have a business, or if you want to run something, and this thing you want to run can only work because of something very special, that's something that you cannot afford to just be out there, you ensure that whoever you're disclosing it to, if you're discussing with an investor, you say you want to go to the table with someone who wants to fund it, for example, and you're going to have to disclose some of these very sensitive things, you have to have an NDA on site. Otherwise, you're literally putting yourself in a position where you have to face a situation where your things are out there, your trade secrets are out there, and now you can't do what you're supposed to do. And your competitors go now. Now, someone who has money or capital will now go after your idea before you do. And because you didn't cover it by an NDA, literally even a lawyer can't help you. They'll take you pay them and they'll take your money, but they usually know a good case and a bad case anyway. Then we have a very unique IP that is coming up. It's very new. It's called TKCE, Traditional Knowledge and Cultural Expression. This one came about because we realized foreigners come to Kenya, they go to grassroots, they go to where people are still very traditional about things, and for example where people are still being treated by herbalists, people are not going to hospitals and everything. They come, like the big farmer, they come to Kenya, they go to the grassroots level, they find out, how do you treat this thing, what kind of herbs do you use, They pick them, go back with them, take them to big pharma, use them to make medicine, patent that medicine, and sell them back to us. The problem with that is that the community that is growing this herb, that's supposed to benefit from this herb, don't know what you've done. They don't know that whatever medicine is curing so many diseases because of their herb, and they can't be able to share in the profit. So we've noticed that, and that's why this IP is now coming up. We have an Act of Parliament. It's still very new, but the core essence of this IP is to ensure that if there's a community somewhere, even the Maasais, they have particular hymns they sing or songs or whatever. Then let's say a white investor comes and they take a video with them with these songs and the hymns. They go back to their country, they sample parts of these songs that have been created by the community, then they put it in an artist's work, then that artist then akulia. Kwenye walitoa huku chini, no one is even aware. They are somewhere in the suburbs, they don't even have internet, they don't know that their IP is being used to make money somewhere else. So this one, just think of it as that. It's meant to protect traditional knowledge and cultural expression, that more often than not, investors come or people come, these guys that we want to help you, they pick a few things here and there that the community does, they go, they commercialize it. That's that IP. Then the next one, and I think the last one, is this. It's also very new. Geographical indications. This one is just that you can patent, not patent, you can trademark. It's like some kind of trademark, because you see it's meant to protect a name, but that name is not just any name. It's a name that, it's an identifier name. It identifies a product to somewhere. So for example, I've given a good example, the Baringo honey. There's a honey called Baringo honey. You see, by reading that name, you can tell it comes from Baringo. You understand? Or a Maasai sugar. you can tell where it comes from. Or like champagne from France or something like that. Or like Kissy soapstone. I think we all know the Kissy soapstone. You can tell it comes, like from the name, it comes from Kissy. So two things can exist in this particular name. You can register a trademark, you can still register a GI. You get. It's also very new. We're trying to still navigate around it, but that's what it is. So those are that's a summary of all most IP rights. There's a plant breeders' rights that Olomo talked about, and it's just basically protecting your rights if you're a farmer and you come up with let's say a unique seed or a seed that can survive drought or something. You can register an IP called a plant breeders' right, so that if anyone else uses that seed and reproduces it with like another plant or like grows it somewhere else without your permission, then you can claim there's a breach. Hi. That is all the IPs in Kenya. The one that touches on you most, I know, is copyright, trademarks, a bit of industrial design, and utility models, because I know patents are a bit, the threshold is a bit high. And which other one do you think touches on you I haven't mentioned? Just those. So we're going to narrow down on those. And I'm going to tell you a guide that you should look, what you should be careful about when you're contracting, when you enter into a contract, and you have some copyrights to protect. Because I know that's what touches on you the most. So we'll go one by one. Let's start with the starting point, which I think I'd mentioned, that whatever you do, just always know that for commissioning works, whoever is paying you to do that work automatically owns the copyright to that work. If you're being called to take photos, to take videos, to shoot a video, someone else is facilitating that, by default, they own copyrights. So always go to the negotiating table from that standpoint, knowing that I've come here, I know the law favors you as a brand, as a company, as a whatever, paying you to do this work. But since I'm the one generating the work, tuanzie hapo kwa who's going to own this copyright. So that we have a clause in the contract that says that these works that are being produced in this instance are yours. So a brand approaches you to create a reel for them, that reel is theirs. They're the ones commissioning that work until and unless you contract otherwise. And you have a contract saying that no, this IP belongs to the creator. Hapo ndio unaanzia. And then you have to identify the IP. Sometimes your work has several IPs to it. I've given an example of a startup there. If you want to start, if you have a startup, for example, in Kibera, there's so many IP rights that are going to come up. You're going to have your copyright in your business idea. You're going to have your copyright in your client names, which you're going to, of course, protect and encrypt so that no one takes your clients away from you. Then you're going to have trademarks in your logo. You're going to have trademarks in your brand name. You're going to have trademarks whatever color you choose to go as your theme, as a theme for your startup. Then you have a trade secret, which is your strategy, which no one else should have visibility to. Then you have copyrights and patents in any software that you create. Let's say you have a business, but this business you can reduce it into like a website or like an app. You still have IPs there. So sometimes IPs subsist in so many things, and you have to be very clear about, I'm entering into this contract with you, but only with respect to my copyright, or only with respect to my trademark. So the lines are not blurred. So it's very clear to this person that this is what you're giving away or licensing. Then we have payments. Look, there is no threshold for how much percentage you should ask for as a royalty. It's your bargaining power. If you want 5%, that's what you're gonna get. If you can push to 10, push to 40, that's what you're gonna get. Because in contract, we have something called freedom of contract. Usually the courts don't interfere. If you come to the court and you say, nilingia kwa contract na mtu, hii contract, mimi sitaki tena inaniumiza, the courts can barely do anything to help you. Because guess who sat there, read the terms and signed? It's you. So unless you can show the court that when you're signing there was a gun to your head, you are being forced, you're being coerced, or you felt like your life was in danger, if you can't prove those things, the court will not touch that contract. They'll tell you, you bargain, they're going to hold you to your bargain, and then you depend huko nje. So it's very important here to take advantage of your ability to negotiate. You're using my work for 2 years, for 2 months. Within these 2 months, you're going to pay me 50%, 40%, 80%, 10% of whatever you make from my work. It has to be there in the contract. Then, transfer of rights. What are you transferring? So there are two things that, as I said, you can either license your work or assign your work. Licensing your work, think of it like this. You have a piece of land. You have a piece of land, then you let someone rent it. When they rent it, out a couple forever. See, wanaweza hama ama wanaweza like a lease. A lease says you stay here for 2 years and you move. That means that land, that property is back in your name. I just change ownership. You just let someone to use it for some time, then they can leave. That is a license. A license is you're going to use my work for this period of time within this particular geographical location or this particular web or this particular social media platform, and just that. Within those 2 years when they lapse, comes back to me. And the licensing can either be exclusive or non-exclusive. Exclusive means if it's an artwork, if it's a photograph, you say you're going to use this photograph for 2 years, just you. Even me as a creator, I'm not going to use it anywhere else. So the moment you give it exclusivity, it means if I contract with you and I'm the one taking your artwork for 2 years, copying it, distributing it and whatever, I can't see you in an artwork exhibiting it at the same time. Because the contract was exclusive, it meant you gave me, just me, those rights to use. And an exclusive license has to be in writing and signed. Anything less, not valid. For pamoja. Now, for exclusive rights as well, the maximum term is 3 years. If you don't renew it after 3 years, it lapses. The thing comes back to you and the agreement ends. On the flip side, there's the non-exclusive licenses. So yes, you're giving your work to someone to use it for a particular period of time, but I can also use it. I can give her to use. He can use at the same time. It's not exclusive to you. So if you see her, also, a good example is NFTs. The time NFTs blew up during COVID time, everyone was buying NFTs and selling NFTs. NFTs is a creation of art, right? You sit down, you come up with a very nice image on that guy who collected like images of him from 2019, makes it like an artwork, then he sells it on Binance or like these crypto platforms. Now what happens is that if I have my NFT and I want someone else to use it exclusively, even me, the owner of that NFT, I can't be selling that NFT on Binance or these other platforms until that license expires. But if you want to have the freedom to still use your work even under a license, you have to make it non-exclusive. Non-exclusive can be oral, it can be inferred by conduct, here in number three. But the exclusive one has to be in writing and signed. That's the transfer of rights. Those are just the basic things you should know, at least when you're going to a negotiating table. Even if you're going to get a lawyer, those are the things you should be able to capture and know. You know what you're doing, you know what you're saying. So, then we have the indemnity clauses. Indemnity clauses are just clauses that say, if anything happens, we are in disagreement. If anything happens, I think a good example is, let me have those forms you guys are looking at, photos. I'll tell them an indemnity clause. Have you guys signed those forms? You're aware of what the implication is. You can't sue these guys. You know that your photos are theirs now. They want to take them today. In perpetuity. You give that clause for life. For life. And you just signed. You're okay with that. Don't worry, I also signed. It's fine. This is an indemnity clause. So me, Vanessa Sifundi, I signed this thing. I release and discharge these guys, this organization, from all the claims, all demands arising out of or in connection to the use of these photos taken today, videos taken today, sound recordings taken today, including but not limited to invasion of privacy, compensation, moral rights. Very heavy statement. You didn't read it. You can't go after them. Even for data. Hata kama uko 8 years old umezeka yako yote and your photo is still on their website, you can't do jack shit about your past. You can't do anything about it. That's what identity clause is. You've covered them from anything. So hata akiuzia wakitaka kuuza wapate pesa to other life organizations, they can. But they also find it.
Just maybe remind a bit.
Yeah.
There was a time when data protection, there was a time when data protection was really a big thing. I think 2 years ago it started up, yeah. And when you got inside clubs, you saw like a poster written that by being inside this club, then you automatically consent to your photos being used in this club. Does that notice hold? Is that consent?
You ask the right person because I'm also a data protection officer. At the office of the police, that's the office of the data protection officer. This is what's up, guys. Initially, that's what clubs used to do. Actually, just by they put there a notice there, by entering, you have consented. Weddings, banners are all over. By entering, this is the position under law. Let's see if I can use my voice. This is the position under the law. That is not consent. When you try to shout, that is not consent. You can actually sue and get really good money. Say what the DPC is giving for that is a region of about 250 to 500k. So kama unataka kuomoka na club, enda club, pigwa picha or post kwa Instagram, take a very quick screenshot, call me, we find it very fast. Hapo kidogo sana labda 250k unaweza toka block na hiyo. So siku hizi what is happening is we have guidelines on that what is required of everyone, and that's why they were doing what they were doing. You need to actually sign. You need to sign. There needs to be, and the burden is on the person who took that photograph to prove that you actually signed that particular document. And even this form is a bit deficient because just for future, it's not. It's perfectly fine. Because you know what people used to do now is that they just have random forms. They have they print like standard forms for everyone. Then they tell you sign. Someone went to a DPC and said, there's a case at the DPC and said, yes, I signed, but where's my name? How can you prove that this was for me? Because it was just like a standard thing. I agree to this. There was no name. That's why there's your name here. That's why they've done that. So now it's the burden is very heavy. You have to sign. What other people are doing is that for people who are like into photography here and videography, you either sign or you give people give wristbands, colored wristbands, so that if you want to be photographed, you take, then you sign, so that whoever is taking photographs, that if they don't see you with that thing, they refrain from taking photos. So it's not consent. That's what the determination is. The threshold is a bit higher. I think most people are like trying to catch up with that right now, and I can see you guys are doing a good job at that. But yeah, that's an indemnity clause. So we were looking at the indemnity clause here. So this is the position that you've signed today. So
sorry, Vanessa. and the burden is on the photographer. There's a photographer, videographer.
Yes,
the burden is on you to ensure that even the wedding photos you take, before you post them on your own
they have to sign
platform, make sure the groom and the bride, just before signing their nuptials,
they sign
your document.
They sign. Usually, so this form, just keep them. Because if I come at you 20 years later and you don't have this, I just ask you to show where I signed it. And if you can't give me this document, so you have to keep record. And for any other photographers here and videographers. Yeah.
Sorry for interrupting. I really also wanted to emphasize, given that most of I also wanted to emphasize, given that most of people, or rather almost everybody also does community photography. Yeah, and I know that is one way of covering events. And disclaimer, we're not going to sell your photos. We just go to ourselves. You know, they always say protect yourself. So we're just protecting to ensure we can communicate that you did this training. But then again, emphasis, it could be you are looking at an organization using your photos. But rather almost everyone here takes community photos that we share anyhow. Yeah, that we share anyhow. And I think there's awakening whereby everybody now understands I could make money using a photo. So just a disclaimer, even though sometimes we get invited to go and cover some events in organizations here in Kibera, it's up to us now to think about developing our own indemnity form, just to ensure you request someone to sign it that you can use that photo for your page. Because it could be a stumbling block for you. Uanze tu kuomoka mara moja, then mtu feel like PJ ni photos kupea ruhusa. So it's more of,
let me add to that. And you know what people do is that, amenisu, ni sawa tu, whatever. Sitajibu. Sitatokea kotini, sitatokea before audit. What's going to happen is that we're going to have a judgment against you in default. So the court doesn't care if you show up or not. If you don't show up, me as a lawyer, I'm just going to tell court, this guy doesn't want to defend, give me a judgment in my favor. And they're going to give a judgment in my favor. Then after that, I execute. I just go to Upper Milimani, I check what you're calling the decree orders, I come to your house, uko na TV in Chindasi, gari uko nayo, I attach and I sell through auctioneers. So ignoring courts and ignoring people like suits against you is never a solution. You still be auctioned at the end of the day. So the first thing you do is you lie to get a lawyer, you defend your position and whatever. But before you get there, as she said, just protect yourself. Always ensure you have those forms, always ensure you have a record of these guys agreed for me to post. And I think most especially because I also do a lot of work with children and youth, is us who deal with kids. Now kids are a different thing now. Because they can't even consent. There's nothing like a child consent and I'll come to you. There's nothing like that in law. So, how will I prove that her parent agreed for me to take my photo and post it on my website? So, Kitambo, I just used to go, I'm called, talk to children, I'm happy. I go, I have like a group of under 18s, like 50 of them. Then they take photos, they post. And then I sat down and I thought, wait a minute. You guys are actually putting me into hot soup. Because the parent sees this thing. And I used to do a lot of talks on sexual reproductive health and whatever. And you know, some parents say like people in parents like who are raising kids like in slum areas and everything. They don't like that kind of talk. They don't want to know. They don't see their children sitting down, being taught about, let's say, contraceptives. They're very reserved on that. So if a point of service people and say, hey, look, we have to see how we are doing compliance here. And even if you're using data even for these guys, they automatically, because these photos you're going to be posting them and doing whatever with them for the purposes of your vision and your mission, but you automatically now become what you're going to data processors and data controllers. And for that, just by virtue of you using this event, photographs and everything, and you'll become the data processor and the data controller, you have to have certain certificates under the law, under the Data Protection Act. So you have to have 2 certificates. And these certificates, you renew them annually. So if you go to court, or if you go before the OGPC, where I do a lot of their matters, and you say, fine, you require consent, do you consent to sign? I'll say, fine, this is my signature, I sign, but on what basis were you collecting my data? Do you have a certificate? Court will say, organization, what is your response? Do you have a certificate? Because you're processing data. You don't. You didn't register with the OGPC, you are still fined. So it's very nuanced, you know. So you have to be very wary of all these risks that come about that. But I think with V&F, I think we're talking about, I've even forgotten.
We're talking about Indemnity clause.
Yeah, indemnity clause. So that's an indemnity clause. So whenever you see someone saying you protect me from everything, any lawsuit, any claims, that's an indemnity clause. Basically, umeingia kwa contract na umemcover. If anything happens, the third party should come at you and not them. You've covered them. So, I'll take your questions. We're about to finish. And I think the next one is payment. I talked about this. So royalties, I think I've emphasized. Negotiate and negotiate very well, because it's your work anyway. They're not doing you a favor. Ensure that for late payments, because brands are very notorious. I think someone mentioned it. You do a job in January. 2 months, you do a campaign, let's say for Maybelline or a skincare product. Campaign in Aisha, they make sales from those adverts, they give you your photos and your videos and your reels. In December, they still haven't paid you your money. So how you remedy that is that you make sure there's a penalty for late payments. You make sure that for every month or for every week or whatever, they default, there's an interest. And for every time, let's say you say it will be attracting a 1% interest per month, every time that 1% accrues, you send a demand letter. Wasipolipa tena next month, April, wasipolipa imeaccrue tena another demand letter with an updated debt. So kama alikuwa na 200k last month na imeipanda mpaka 215k, you send a demand letter, a fresh one, saying, look, this was our contract, you breached, you not paid me my money, and now this is just to demand for you to pay me now, 215 plus what? The interest. You do that for every subsequent month until they pay. And if they don't, and you go to court, you have a trail of evidence. Thing is, if you see mtu anaanza kutumia mabarua mingi, anaanza kurecord vitu mingi on paper, that person is going to sue you. That's where that thing is going. Because they know when they get to court, they'll need to produce that paper trail. And that's exactly what you should also do with those brands. Everything in writing, hakuna cha urafiki, that will mess you up. So everything you make sure is in writing. And then I talked about these kill fees. They are very notorious as well for this. A brand will contact you to get a reel for them. After you send them your first submission, they tell you, oh, campaign funding imeisha, we won't be proceeding with your contract. But they already have your reel already created. Then 2 months later, you see it on their page. And they had cancelled your contract. You can sue fine, but court processes are very long. The easiest thing for you to have is a kill fee in your contract that says you're gonna pay me. I don't care what will happen in your project, but as long as you have given me this contract, una deposit kwanza 50%. Saa hii ndio kazi ianze. And then whatever happens in the future will sort out. But that's a kill fee. But if they cancel this project post delivery of your work, you at least have something. You know, umeshinda kukosa anything, and your work is still being used for free out there. And yeah, there's that. And then again, I talked about this. If they're also notorious for sending back your submission, telling you, the lighting is not okay, fix the lighting, put the product vizuri at jina, rudia hiyo reel, rudia nini. Ensure that your contract covers such situations where you're being asked for extra content beyond what you have been told to do. You're being asked to reshoot things. You're being asked to submit. The agreement was I submit 1 reel. By the time I'm done talking with you and negotiating with you and the contract, executing the contract, you may prepare 15 reels. That's beyond what we agreed, isn't it? Yeah, and usually for this, because these are very extraneous demands, you're better off going there with a lawyer. Kama ni kuashtua tu unajua mtu. You know, sometimes, I don't know, there's just some authority that they've come with their lawyers probably. You just go and you're just an artist. They think this guy doesn't know the law. If you go there and you have your lawyer there, they're going to be a bit more careful. Yeah, the way the police, wakikushika, na uko peke yako, they will do so many things to you that are against the law. Chakwambia, leta fingerprints. Sijui, kaa hapo tunakuquestion, you have to give us an answer. You don't. But because you're alone and you don't know, you want to pee on your pants, you're very scared, you're going to be yapping there and criminalizing yourself. If there's a lawyer there, they don't do that. Because they know the lawyer will interject and say, you're beyond. So even if it's just for appearances, always carry a lawyer. Doesn't have to be an advocate. It can just be a lawyer who's going to law school and graduated. So just for the authorities' sake. That way, it's easy to negotiate this kind of clauses because they won't easily agree to them. It's detrimental to them. Then push back. If you're alone, they'll make you think that this is, I'm doing you a big favor. You know, nakataa kuchukua contract na nimekuja. I am Nivea. I am PSG or whatever those football clubs are, and I'm calling you to use your image, and you're telling me to do what? I'm doing you a favor. You'll be famous. No, but my pocket, I'll be famous, but I'll be broke. So that kind of thing. I talked about exclusivity. What I didn't touch on was the fact that you should also consider what you're calling carve-out clauses. So you see, what brands will tell you is, we'll use your content, and you'll do this campaign for us. Let's say a skincare brand like, let me not mention name. Let's say skincare brand X tells you, come, we have this campaign, please advertise for us. Then they say, but when you're advertising for us, you can't do campaigns for company Y because they're competitors. Makes sense, right? But you see, you have to have a carve-out clause that says, okay, you've got me at this point, I was already campaigning for company Y. So this contract should be to the effect that because you already found me campaigning, this exclusivity excludes the company I'm already working for. So I can still continue working for them even as you give me this contract. The other way you can look at it is, fine, and I usually advertise for Nivea, for example, but I use Nivea. My skin, I don't use their skincare products, I use another product. But the cover should also cover things that you use, not commercially, just your normal daily use. And then it should be very specific to the fact that, fine, I'll only be campaigning for you, but for this, because I'll only be campaigning for you, you have to pay me more. Because I would have lost, I would have had potential brands approaching me for this period of time, now my block, by telling me you want exclusivity. So your fees should be at least twice what they would have ordinarily paid you if you are not just advertising for them. You get, that's how you negotiate. You say, fine, I'll accept your terms, but honestly guys, if I'm just advertising for you, I'm turning down many other proposals and many other brands that are approaching me. So at least for that, you need to ongeza kitu kidogo. And it has to be very specific. Don't let them chain you to a long period of time. Don't let them chain you to, some of them will say, you can't advertise anywhere. Anywhere, whether it's Kenya, Africa, whatever, or you can't advertise in any other platform, whether it's Instagram, they chain you. So you have to make sure you read those pieces very carefully and you negotiate and you push back. Don't be walked over. Then of course there's confidentiality. This one is a must. They specify the kind of things they need confidence. So the things that you're likely to come across when you're interacting with them, their trade secrets and the like, their IP, their own IP. So you find those pieces there. Then termination, ensure there's an opting out mechanism. Don't be bound by a contract that doesn't have a termination clause. And ensure that it's both ways. Either they can terminate or you can terminate. What you'll find most of the time is that they have termination process for them. Saying, in the event we discover to do what, or in the event we, even sometimes just no reason, we can just send you a notice and we terminate. Ensure even you, as the other party, you have a right to terminate that contract. And ensure that there's procedure both ways, so that someone doesn't wake up one day and just terminate. They have to give you a notice, they have to give you a period to rectify whatever they think is going wrong, or they have to they have to be leveraged there. It can't be arbitrary at nimeamka tu leo sijisikii tena kufanya kazi na wewe na nimekata. So you have to make sure that it's both ways and it's fair. So that even if you want to terminate, it's also fair to them. Then this is dispute resolution. This is like ADR. ADR is alternative dispute resolution, litigation, and the like. So I had someone ask here, actually, he hears his song being used by Gachagua at a campaign trail. I think, yeah. And he was like, how can he sue? Gachagua has a lawyer, has a big lawyer, and stuff. And that's very true. Because if you come to me and you're going to sue Gachagua, I'll be ready, but yeah, but it's like, I get the power discrepancy. But I think the beautiful thing about this IP violations and whatever is that we don't always have to go to court. I mean, everyone is told, sue, run, courts right now have a backlog of 6 years. Like kesi ili failiwa 6 years ago ninaanza kusikizwa saa hii. if your matter goes to court now, guess when we'll be hearing your matter? 2020? Yeah. So, I think I don't think I introduced myself, but I'm also a certified mediator. And I'm always trying to strike a balance between being a usual aggressive litigation court, suing people, lawyer, and just telling my client, it will never. If we can talk to the other, we can literally talk to the other side. I can just call their lawyer and say, hey, come to the table. But the lawyers, we know, like client anakutana anasema court direct, sitaki kuongea nini. But lawyers can always talk and say, hii kesi ya mtu wako unaona aje? Anaona tuambie waongee. So that's ADR. So it's negotiation, it's mediation, and it's very party facilitated. Lawyers don't even talk much. They just advise you if you accept this is the implication, if you don't, this is the implication. And most of the matters we do, big matters actually, people just usually talk outside. Ikikataa kabisa, sawa, let's go and fight. So something like that, ADR is a good thing to start with. Tuma demand letter, wasipojibu, try to negotiate. If they don't, go to court. And courts are usually very friendly to parties who try to negotiate because they can see the good faith. You understand? So that's dispute resolution. So make sure your contract also has a clause for dispute resolution. Dispute will come up. I don't care how much you think you're buddies. I don't care how much you think we're such great friends. This business, we're doing this business together. You can never go wrong. This is my person. This is my boy. It doesn't work like that. The day you have a problem and you go to your contract governing that particular relationship and you realize, oh my God, we didn't put a dispute resolution clause. That is the start of your problem, the beginning of your problem. So always ensure you have a clause saying, if we disagree on anything around this contract, it's usually a very holistic clause. If we disagree on anything to do with this contract, payments, timelines, what else can come up in such a contract? Payment dispute, timeline dispute, breaches, someone has used something beyond what you agreed. This is how you're going to solve it. Appoint someone who can solve it. Is it a mediator? Is it a judge? Define the laws that govern. Is it Kenyan laws? Are you going to go to Kenyan courts? Are you going to go to tribunals? Are you going to go to... Yeah, so all of that depends on how you and your lawyer and another lawyer negotiate, or you and another person negotiate. But those have to be there. Those are like some of the things you look out for in contracts. I think generally, yeah. And then I think for that, I think we put a pause on that. Up to there. So are we still together or have lost someone? We're together, perfect. We move to profits, and I think I already touched on this. I talked on licensing, and I made a very clear distinction between exclusive licenses, non-exclusive licenses, what they entail, how long they last, what you should be careful about, and assignments. Assignments is now how you now sell your land to someone, and that land completely goes to another person. You cannot claim it. You cannot claim it back, it's transferred. The same thing with IPs, but now in IP we call it an assignment. Your rights, all your rights, they go. But with assignments, you can either assign it wholly, so all of it, or just partially, maybe just 50% of it, or like a percentage of it, or you can also use it. So those two are how you can make money. You can make money by licensing and getting royalties, or you can make money by assigning, that is selling and getting payments for that. And for this one, you need to charge very well, because you need to value your work even in the long term, because your work is going, so you'll never see it again. This one is kind of a bit more reasonable, because eventually your work will come back to you after a few months or a few years, depending on the agreement. Then the other way you can actually kind of not make money per se, but use your IP to profit off of it, or like to gain something out of it, is by using it as a security. I think I mentioned when I started that right now we have an act called the MPSR Act. This is the Movable Property Securities Act. This act allows you to use IP expressly as a security for anything really, for a facility, for a mortgage, for anything. As long as you can value it and show that it has some kind of value attached to it, then you can use it. You can leverage on it as a security. Yeah, and I think that's that. I think we've seen what IPs are, what they look like, the kinds of IPs you can explore, the kind of things to look into when you're trying to negotiate on your IPs. Now, let's say you've been negotiated, you've entered into a contract, everything is good. How do you identify that someone has breached your IP rights or someone has, quote unquote, infringed? Someone has done what was against the agreement, or there's not even any agreement. You've never seen this person in your life, and they're using your work, they're using your video, they're making money out of it. So you identify that by one, you see what you've said. You're chilling and then suddenly your video is trending and someone else is posting, reposting, distributing, copying. If it's your book, you, like I see a lot of these poor streets, the CBD, you find that people are selling books, but like ukifungua hiyo kitabu, they've literally photocopied the original author's book, then they're now selling at 500 book. If you go to the original author's website, it's like 1500. A good example is just Jackson Biko. He sells his book at 1500 in his website. Then unaenda pale CBD, some random seller and they photocopy like 20 pieces anauza. That's a breach of IP rights. In fact, I can just decide to tip off the author and say, hey, look, this particular person has been selling. Are you aware? So that's how you know there's a breach. Someone is reproducing your work, copying your work, reselling, rebranding, whatever. You're seeing your logo on shirts, you didn't authorize it. You're seeing your music being played on an ad, Safaricom ad, you didn't authorize it, and things like that. So that's how you identify there's a breach. Someone is using your work against your will or like without your permission, and they're using it to make money. So, and then, so it's an unauthorized or unpermitted use of the whole or substantial part of your works. That is a breach. However, sometimes someone can just be using it as a fair use. Like when I was in campus, I remember we used to photocopy a lot of the books in the library. That's for academic purposes. I'm not going to make money. I'm not going to benefit anything out of it. That's an So if you take me to court, let's say the author of a book called Land Law, for example, takes me to court and says, you photocopied my books. Or like our lecturers, they used to photocopy notes from textbooks and give it to us for studies. That's an exception. To barely see a day in court, because like you can't prove that this person has violated your IP rights by making it commercially viable for them. Or like for research purposes, like when we used to do our dissertations and the like, and you're doing out of research and you have to borrow from other artists' literary works and the like. And also, I think an exception is where your work is being used in a court as an exhibit. If there's a case, if there's an ongoing case that requires the use, let's say samples of your artwork as exhibits just for court purposes, then you can't sue the court or the lawyers by virtue of that. So those are some of the exceptions that you can use. So you also have to be very careful that you're not pursuing something that's very futile at the end, just to be a very strong case, something like that. Yeah. So let's say you've discovered there's an infringement. What are you supposed to do about it? And this is where we have the remedies coming in. The kind of things you can pursue to make sure your rights are covered and the like. So the first one I think I mentioned, and I plugged myself very strongly there as a CPM. You can negotiate, mediate. I mean, not everything should go to court. I know it's a bit unusual coming from a lawyer, but I think having seen what happens in practice, not everything you have to drag in court. Sometimes, whatever you can negotiate and get paid out of as a settlement is much better than what you could have gotten in court anyway. So just make use of ADRs. We have so many mediators right now. It's actually very expansive because now we have trainings every other month. So we have certified mediators everywhere. I think Wambogo here, he's part of the LSK. He should have told you that they have a network of pro bono lawyers in the LSK. We have a pro bono committee. Pro bono just basically means a lawyers that help you without you breaking sweat. It's almost free. It's not free because you have to pay for like filing fees and transport, the lawyers transport to come in, but lawyers fees, you either don't pay, you pay very minimal costs, yeah? That's the pro bono network. They can also help with negotiations. And I told you, like, when you're going to negotiate, it's always good practice to have a lawyer, just for the optics of it. Less costly, less time consuming. There's arbitration. Arbitration is a bit more costly. It's reserved for like corporate bodies, and corporates don't want their dirty business aired out in a public court of law. Because arbitrations are very private in nature. So if you're a big corporate and someone has a problem with you, they usually tend to draw you into an arbitration proceeding, which is private. It's a bit more polished. So it's quite expensive. People say it's cheaper than court proceedings. I don't think so. I think it's very expensive. And the like. Make use of demand letters. Demand letters are court advocate tu yoyote anaweza kudraftia at a very small fee, a few thousands, just a few. But if you get the ones that are so within our advocate networks, we have advocates who are extremely undercharged. If they do demand letter for you for 200 bob, it's a problem in the profession. But I think letters are something that I can even do for free, because it's just like trying to communicate your problems to the other person and saying, look, either come to the table we talk or I go to court. Most of them wanareply nasema tu sue, you can sue. But I still feel it's a good avenue to use. Then there's this. This one is a very important one. Take down notices. This is an express remedy under the Copyright Act, and I also think the Trademark Act. What happens here is that if your IP is being infringed on a platform, let's say Instagram or TikTok, or it's being infringed through an internet service provider's network, let's say Safaricom or the like, you don't send the person infringing the notice to take down that content. You send the notice directly to the platform. So let's say you send the notice directly to Safaricom, or if it's a website, that website, or if it's a social media platform, maybe let's say Instagram, directly, then they will forward it to whoever is subscribed to their network and tell them, we've seen this, it's saying you're infringing someone's IP rights through our platform, can you take it down? If they have a counter response, they'll counter response. But this is very effective. This is very effective, and this is what you usually do when you report people on TikTok, for example, and then the thing is taken down. So something like that. So those are some of the at the very initial stages, the things you can use to sort of like come to an agreement with someone who's infringing your rights. Now the more serious one, these people don't listen. They don't want to negotiate. They don't want to mediate. They don't want to talk. They're disregarding you, whatever. Now you can go to court. And now when you go to court, there are certain things you can do in court to get reliefs. We have what you call interim relief. I told you right now courts have a backlog of 6 years. Kesi yako ikianza kusikizwa, ukifile leo, it will take another 6 years to be heard. That's a long time. So what now the law has done, it has what it calls interim remedies or interim relief. This one, you can get orders immediately before the thing is heard. So you can even file today and get orders tomorrow. You know, because you file like a what we call it certificate of urgency. So interim reliefs are like injunctions. So injunctions are like the court giving an order for someone to stop doing something until the case is heard. Now, if you get an injunction and the case is heard till 2030, that's good for you, because this person will be stopped from infringing. If it's like posting in press your order in such a way that the court demands or orders this person to stop, for example, distributing your work, to stop, for example, photocopying your book and selling, and when they don't follow that order, they now can sue for contempt, which is very serious. They can even go to jail for that. So injunctions work pretty effectively, except for but injunctions work pretty effectively because they restrain immediately. Before anything else is done, they restrain immediately. So those are injunctions. So they can restrain the defendant from continuing with the breach, whatever it is they're doing. Stop at that point. Then other interim reliefs are ad hoc orders. The beauty of ad hoc orders, these are orders that you get from court Expert means by yourself. You haven't informed them. So let's say he's the author selling my book in CBD. I get a read of it. I know where he stays. I know probably in his house. If I raid his house right now, I'm gonna find evidence that he photocopies my book and he has copies of my books. Did I need to know? I just go to court alone. That's what I'm calling expertise. I go to court alone without his knowledge, without having him, without him knowing. I get orders from court, and pillar orders. These orders allow me to raid his house, to collect the evidence, and to do what else? To preserve. So you can collect infringing materials, you can collect illicit copies, and you can collect evidence. The beauty of it is that it leaves the other side, it finds them off guard completely. They don't have time to hide those things, they don't have time to run away, because you got those orders without their information. They're called expiry orders. So this is like one of the most effective ways to immediately get a solution. Then now there's damages. Now this one comes at the end of a case. These are not like interim, like immediately before the case is heard to the end. These come at the end, but the court decides whether you're entitled to damages. That is, damages is just like, think of them as money, payments to you for whatever reason, whatever injury you have suffered. If it's because you feel like they should have paid you royalties, the court will calculate those royalties and award them to you if you've proven your case. If you feel like you suffer a certain kind of loss by the fact that, if it's a trademark infringement, for example, your business suffered because someone else was trying to pass off on your business, you can claim for the losses that you would have made, for the profits you would have made had this person not tried to pass off as your company or your business. So there's a calculation. You have to prove what you're calling special damages, that's how much exactly did you lose. So depending on how strong your case is, you can actually get something really good out of the court from this one. But this one is not always ascertained, because cases can go either way. I mean, judges retain what you're calling discretion. They can decide in your favor or not. So usually we can't tell you at you utashinda 100%. Ama you lose. So many factors go into play with that. You can also pray for payment of royalties. I think I've said this. Or you can ask them to account for profits. I think a good example here is if you're two artists and you've collaborated on a song, and the other artist goes ahead and starts selling your music and reproducing it to other people without your consent, in that arrangement you have equal ownership of that particular IP and you should benefit equally. So if you're going to sue him on that basis, you can ask the court to ask him to account for whatever money he made from that infringement. If he says, hey, from that infringement or from like selling this thing to other people, I made like 1M, you ask the court for that 1M. That's what that means. It's like you ask the other person to account for profits and you demand that those profits be paid to you because of what you suffered. Then there's the destruction order. So this is tied to this Adolfila one where we were saying, let's say you've raided someone impromptu, you've taken evidence of this person breaching your IP rights. A good example is that book, the book example. The court can order a destruction of all those books, everything that you think is infringing on your rights. They can order that they be destroyed for good. And I think, this one is usually the first prayer, of course. Before anything else, the court must declare that you're the owner. So you have to prove ownership. If it's corporate, you have to prove that this was your idea and you reduced it into something tangible at this particular date. You registered it. A good example here is if you can produce a certificate of registration, it's prima facie evidence that that is your copyright or that is your IP. So always have a certificate on standby. You prove this, the court declares ownership, then now we move to other issues of infringement. This is now the ODPC database I was talking about in terms of so ODPC is the Office of the Data Protection Commissioner. This office is on fire right now because everyone is suing for breach of data. Everyone is just, I've seen my photo on your Instagram, ODPC. I have seen these people who text you randomly they are vying to be for which position. Please vote for me. The first question is, where did you get my number? Who gave you my number? That's a breach. My number is my data. I didn't consent to my number being given to you, I didn't consent to you texting me. So that now everyone is taking everyone to the DPC. Like the DPC is actually giving such good remedies and such good amounts of money to people. People are motivated enough to look for a breach and drag people to the DPC. So that is one way of also making a good killing. Because the DPC makes a determination in 30 days, 60 days. 60 days, and you have your decision. A court will take you 6 years. So will you go to court and sue, or will you go to the DPC and get your things in a protection violation? Go to the DPC, obviously, right? Yeah, because you're looking at the timeline. You want to make sure that at least it doesn't take too long, longer than it should. So those are some of the remedies that you can use when there's a breach. And I think finally, who can you approach? You can approach me. You can approach the KEKOBO. This is the body overseeing copyright infringement, violations, and the like. You can approach the societies. I think Wambogo talked about collective organizations where, like, if you're all artists, you have like an organization that looks out for your interests. There, you can collectively like pursue your rights if there's a violation. And I think the artists in Kenya are currently like very proactive with that, because I think there are times they were being paid. I saw King, is it Calligraph or is it King Kak? He was complaining that he was paid 1,000 bob for as royalties for his music for a period of 6 months. You know, so things like that. You know, these collective management organizations are very good with things like that. So if you are an artist, if you're a musician, join CAMP. CAMP is Kenya Association of Music Producers, or join Music Copyright Society of Kenya. If you're a performer, join the Performers Rights Society of Kenya. I mean, for every category of artists, there's a society, so you just need to find out which one it is. For trademarks, visit KIPI's offices in case of anything. That's the location, there's somewhere along Wariaki Way. And then there's the legal aid services. I think I'm very happy to hear that there are plans to develop a legal aid facility. I think that's very nice. And I think that will address some of these people's issues, because I think like standard form contract. Someone said, can we just have a standard contract where other than akili, I like have a contract that covers like 80% of what I should have in a contract. Every contract has to be reviewed anyway, depending on the circumstances, because circumstances vary from one person to the other. But there are some standard things that have to be in every contract. Legal aid clinics are very good for that, because now that's where lawyers come together, whether pro bono or otherwise, and they can come up with things like that. They listen to what background from standard from contracts. They come together, they come up with something that can help you start the conversation with the other party in terms of negotiations. Then also have the LSK directory of IP lawyers. We have like a whole directory of IP lawyers. Some of them will charge you, some of them won't. Depending on who it is, but that's a good place to start. And I think also picked on this Kibera Community Justice Center. And I think, and I hope, that's the end of my presentation to you guys. And it's now time for me to ask if you have any questions. Yeah, talks too much. Those are my contacts. I'll leave I'll leave a few of my business cards here, just in case you need to contact me for anything. But I think that's the end of it. Let's have your questions. Let's answer them. So there's two things to this. It's two ways. Either I've done so well, you've understood, there are no questions, or I've done so poorly, you're bitter, there are no questions. So, let's see, do you have any clarifications?
I feel like I'm a victim of being manipulated by the society. In 2006, there's a NGO that took our photos around the river. Then after a while, we know that we went and drafted a calendar. Mm-hmm. And what we wrote there was something that I want to say, but I will say it back. These are the kids that suffering from AIDS from Kibera. So it was a long time, 2006. So after this session, I've realized that there are a lot of things that we have gone through as a society down here.
Yeah.
That somehow maybe information for us we are lacking. But again, nowadays, from the word go, I've been doing things, but I've been doing them. You find like I know I took a proposal somewhere, in one of these big schools, proposal. And they were telling me that you need to write a letter, proposal letter, and you have to give some materials. So I was like, Malena, if they go ahead and do something with materials, and I don't have any agreement with them. So what will happen with materials of mine? Me too, because I now it's doing here. Thank you so much for that information. For the future.
Have an NDA, always. These proposals, do what? Just go there with the things. What is your procedure? I understand you have internal procedures, but if you want me to live with you any material, if you want me to live with any material, make a signature. That's how you do it. Because you leave your things there, there's no, they can even say, as we don't know you, I've never seen you in my life before. Because there's nothing in writing, you know. So yeah, I'm glad at least I shed some light. And I'm so sorry about that. In fact, when you're describing that situation, I thought about so many things in my, I think just the lawyer in me. Because I'm like, first of all, that's even defamation. Because what do you mean kids with HIV? You know, there's this NGO that was posting kids' pictures as, you know, like some form of, oh, we're helping African children or whatever, but so they were sued on the basis of data breach, because the kids' parents, first of all, those kids are not needy kids, they are kids who have families and everything, but when this came to light, the parents came together and sued that organization. And I think at the end of it, apart from the fact that there was relief to the families, from the fact that there was actually, what is it called, a discovery that particular website was a child trafficking website. So you see, if everyone was silent on it, no one would have ever found out. And that's the problem with IP. With IP, you have to be proactive. You have to be the one to identify as a breach and follow and sue and whatever you choose to do. If you sit back and it's continue, no one is going to help you. You have to be very proactive about your life. That's just the unfortunate part of it. Yeah, but yeah, I'm glad. I'm sorry about that. Can you still sue them?
You can make some money.
Yeah, thank you. Any other here?
There is an audiovisual contract. It can be either a video contract or an audio contract. Is it there?
So contracts are several. Thank you for bringing that up. Usually, we as lawyers, we prefer written contracts because, of course, it's easier. It just makes our work easy. If I just go to court and I just produce it and like, this guy is a contract, it makes my work very simple. But just because you don't have a contract doesn't mean we can't fight. We can't still fight your case, because contracts can also be inferred by conduct. Just by conduct, we can infer a contract. If for example, what's a good example of a contract? By conduct. If for example, I tell you, hey, niko na gari yangu kakaso hapo ni ya kitambo, nataka kukuuzia, yeah? There's no agreement, yeah? But you give me the money, yeah? And you can show that maybe you have WhatsApp texts that you are discussing about this thing, and you can give me an M-Pesa showing that you send this particular money that corresponds to whatever you have agreed to. If I take that to court, I can argue it's an implied contract, both by words and by conduct. There's no written anywhere, but I can imply, the court can imply that there is a relationship of that, of sorts, or something like that. Yeah. So it doesn't have to be written. Just bring your case and see what to do with it. We can always find something. It's not completely hopeless because there's no contract in writing. But always try to have, just make everyone's life easier. Yeah. Any other question? Yeah.
Yes, if I'm asking about ownership of copyright. Let's say I've recorded the song of this guy and said now he owns the song. He owns all the rights of the copyright. What about the style that I used? How is it protected? The style that I used to record as a videographer, the ideas that I had on it. how is it protected?
So let me see. This is an artist.
He's an artist.
He's shooting a video,
Yeah.
but you are shooting the video.
Yeah.
Okay. So you remember what you talked about commission works? Is he paying you to do the video?
He did, yeah.
What is the law saying about commission work? Who owns the work? The commissioner. Whoever is paying you to do the work. If you want any kind of entitlement, you have to continue. It has to be compassionate. Because the law as it is assumes he has those rights. It's section 925 of the Copyright Act. It gives him the right. Statutorily under the law, he has the right. If you want anything other than that, you need to agree and put it down in writing. So if you are shooting for someone and they are paying you to do the shooting, whatever you produce is theirs. If you want any rights to that thing, contract. There's no two ways about it. If you're working for your employer and you are hired, let's say, as a graphic designer, everything you design, whose is it? Your employers. They are paying you to do that work. It's not something you wake up one day and you're doing for yourself. You're doing it for someone. They own it. If you want any kind of rights there, agree and put it down in writing. That's the only way. Especially because the law is pro-commission. It's not pro-people. Whoever is doing it. Yeah. That answers your question? Or there is a follow-up?
Is it right if someone has a original idea, but I come with a different way of expressing it? Can I have the copyright of that? The expression, or does the copyright only protects the ideas and not the expression?
Copyright doesn't protect anyone's idea. It doesn't. What it protects is the expression of that idea. So for example, you have an idea. What's a good example? You want to start a hotel. You want to start a fast food thing. Yeah. You come and you tell me, nataka kufungua hoteli, tutakuwa tunapika chipo na kuku na nini. Right? And then I say, that's a good idea. But naona get with the burgers. Yeah? Or we just do it a bit differently. At that point, your idea and my idea, they're just ideas. Right? They're just in our heads. They're abstract. They're not protected at that point. Copyright does not protect ideas. What it protects is if I go and I say, hey, niliongea na, sorry, tell me your name. Owen. Niliongea na Owen, and I think, hey, his idea was nice, but I think I'll modify it a bit. And then I'll come up with a business idea. I sit down, I jot the business idea, whatever. The moment I take my pen and put it in writing, this is my business idea, I have the copyright to that. Alternatively, I can tell you, come together, give me your idea, my idea, your idea, tuweke chini. The moment you put it down in writing, we jointly own the contract, the copyright to that particular thing. So it just depends on how fast you are. And that's why we usually advise that if you have an idea and you still don't know how to execute, either keep shut, or if you have to yap about it, can you just ensure that the person you're yapping to signs an NDA or something that protects your non-compete that says, this is my idea, I'm sharing it with you, but I'm barring you and I'm preventing and I'm contracting you to prevent you from trying to execute it as your own. That's a contract. So everything I think comes down to that.
So it is right, like he has talked about something in his content, and I am doing another content of telling people how he said about something.
Sorry,
I'm talking about how about his idea on something. Am I
talking about his idea on something?
Yeah. Like,
he has.
Like how Nairobi goes is saying, they give out opinion of someone's opinion.
No, there's no copyright there. There's no copyright there. Copyright is with the author who first did the thing. So if he had the idea first and he reduced the idea into some sort of medium, either video, photograph, audio, writing, it's his copyright. It doesn't matter what you do after. In fact, if you do anything on it afterwards, it's a breach without his consent. Yeah, unless it's for fair use. You can argue fair use or like just fair commentary, like what I do because Gossip Club does. Usione hivyo wako na lawsuits kadhaa kotini. They are sued every day. Data breaches, image rights, defamation, nini. So even then they're not having it easy. But yeah, you can argue fair use. We're just fairly commenting on. We're not making money out of it. But yeah. But copyright vests on him. I think I get your question. Copyright vests on him. It doesn't transfer by virtue. It does not transfer by virtue of you commenting on his thing. Does that answer your question? Okay, perfect. Yes, any other question?
Mine is not a question. I loved your presentation.
Yes.
And we want to take away Scala. So I was asking, requesting if they can also take away the presentation now.
My IP, that's my copyright. Sure, but it's for fair use, it's for your education purposes, so there's no breach there. So I'll share it across.
Okay.
But if I see it on some website there, I'll come for you. JK, just kidding. Yeah.
For example, community September. So, in the protest, sijauliza kama ni au sio, wanaweza kutetea
You, let's see. So you've gone on the finance bill thing. Let's see if I've gotten your question. You're saying you're a community storyteller. You've gone for a protest. You have taken photographs of people. How have you used these photographs?
like
Inform me what is going on. So you're asking if they can sue you.
for example, how natetea nyumbani.
So remember we were doing the exceptions to corporate infringement. We had fair use. We also had when you're using when you use content or someone's copyright for what we're calling purposes of information. Caricatures. Caricatures is the way you see someone like, what are they called? A politician. A politician's image is like he has a big nose or something, and he's being, like as a cartoon to demonstrate maybe something that is happening in society. So my answer to your question is yes, someone can sue you. You can't stop someone from suing you because if they decide, if they think the rights are violated, they can obviously sue you. But I think if you're on the other side and you'll be sued, you have a good case to defend because you can easily say that the content you are taking and sharing was for information purposes. 1. 2, there are no evidence that you made any commercial use of it in any way. It's fair use. It's just to inform people that this is what's happening, and in any event, it's a public interest issue. Everyone in the country knows there's protest. Everyone wants to see what's going on. So you have a very good case to defend. They can sue you. Anyone can sue you for the silliest of the reasons. Sometimes you look at a document and what is the person even saying in this case. So you can't prevent someone from suing you, but you can defend very easily. Yeah.
My second question is,
just make sure you're not sending those things to CNN and the BBC, and they are airing them, broadcasting them. Now that will change the whole case.
another question is, for example, umenipatia hii project.
Yeah.
So I'm a photographer or a videographer.
Yeah.
You asked me to give you photos and videos. But kwa contract yetu inasema edited videos and edited photos. So akona right ya kuitisha raw footage zangu.
No. I think for see, the beauty with contract is, and I told you, court won't touch that contract. If you go to court, let's say she dragged you to court, like you refuse to give me raw photos, the judge will do one simple thing. What is the contract? Let's read the contract. What does the contract say? Edited. Madam or sir, do you have edited photos? What do you want? It's a court of evidence. It's not a court of emotions. It's not a court of emotions. You can literally. So no, that's how you. Yeah.
My question is, what happens to the copyrights? Nikiamua kuuza assets zangu, like the songs, what happens to the copyrights?
If you sell your song,
Yes,
contextualize.
like nimefanya ngoma na nina copyright, So it's like kama asset. Nataka kuuza hiyo
Yes, it's an asset.
hiyo ngoma nimeuzia mtu fulani na the copyright is mine. So what happens to the copyright?
I mean, the copyright is in the song.
Yes.
So you are selling the song. When you sell the song, you're also assigning the copyright. Because the song and the copyright is the song. The copyright comes from you recording that song. By default, you don't even have to register it. So when you sell it, you also assign the copyright in it. And if he's a smart person, if he's a smart buyer, he'll include it in the contract. He'll say the song transfers as well as all attendant rights thereto. That includes your copyright. Yeah, that includes your copyright. Yeah. Everything goes. Yeah, you can't say take the song but the copyright is mine. None will accept that.
That's like giving with one hand and
Yeah, it's a
taking
road
with
deal.
the
Hata
other.
nisi sikubali.
You can't use your song.
Hapa nakuzia nyumba na baki na land. I can come and demolish anytime. No. That's a different game. But if they are slow, you can fix them. But if you most of these guys are smart, so they won't accept it. Yeah. And then sue you when you come and for a lot. Yeah.
The ownership thing. It's you're saying the live thing, and then after you go like go to Zion, it goes to 50, right? So you've seen the cases of MJ and of Mali. Like it's still going. Probably hasn't gotten to 50
Yeah.
since they departed yet. But assuming you have your lining after you departed and they know the essence of the work that you did before them, and it happens your work goes over the 50 and your lining is still there, can they still renew what is rightfully from their tree?
It's a good question. It's actually a very good question. I didn't think of it. But if I'm going by my knowledge on succession, this is the thing. When you die, okay, so copyright protects your work during your lifetime and then plus 50 years after you die. But you see, the moment you die, I know the protection still subsists for 50 years, but the moment you die, your rights, I don't
Transfer
say,
to your family,
yeah, I
right?
don't say transfer.
Transmits.
Transmits, that's the one. Transmits to your estate. Whenever anything, any asset of yours, because now we're looking at it as an asset, right? Whenever any asset of yours transmits to your estate upon your death, the title changes. The title of that particular asset will change to your beneficiary, whoever is taking it after you. Then I'm thinking now, if your beneficiary takes it up and the title changes to their name, that would mean that they will enjoy 50 years of your work after your death. And as proprietors, I'm thinking there shouldn't be anything barring them from renewing it because they're still alive. So I don't think I've ever thought of it like that, but thinking on my feet and how the law works, I don't see anything barring them from renewing just by virtue of them being now the current owners of that particular copyright because they're alive. So I think it's something I can comprehensively get back to you on after I do a bit of reading, but just off the top of my head, I don't think there's anything banning your estate or your beneficiary from renewing your copyright after the 50-year period lapses. But let me get back to you more comprehensively on that.
Yeah, maybe just to add on what you're saying.
Yeah.
Like when you do succession, the properties, the title of those properties change.
Exactly.
Let's say, for example, Vanessa is my child. So the property, the land property that I had was Yvonne. Once succession has been done and completed, that title will be registered under Vanessa. So that means Yvonne is no longer part of any records or documentation. So that copyright will belong to Vanessa, and it will follow that exact rule that it will belong to Vanessa and even 50 years after that died. So I think it's more of a it belongs to you in perpetuity. After you die, then moving to your descendants back Chinyan until
Can be passed down.
can be passed
I
down.
think I agree.
Yeah.
I agree.
So literally, it just remains in family.
Literally, yeah.
So it's like,
Unless,
Vanessa can also sell it.
yeah.
now again.
Sorry, before you continue. It remains in the family unless with a jointly owned copyright. Because now when it's jointly owned, what happens is that in a joint ownership setting, so me and you, right? Yeah. Me and you come up with a copyright, we jointly own it. If I die before you do, you take my portion of the copyright. You get it? It's a joint ownership. If I die before you do, you take the portion of the ownership. Then if you die, the 100% goes to your side of the estate. You get it? Unless we agree on a separate ownership structure, also called ownership. It's called ownership in common, where we own it jointly. I die, my portion doesn't go to you, it goes to my beneficiary. So it depends. I won't say it stays in your family, it depends on the situation. If it's just you owning the copyright, fine, it will go to perpetuity. But if it's a joint ownership, the thing changes slightly.
Just on the same question,
Mhm.
you say the name changes.
Mhm.
Now I'll ask in reference to the Mali,
Mhm.
the Mali's way. Like I don't know, they're parting the name or
The name Bob Marley.
know, like the Mali. Like
The
everything
Mali.
they do, like even without their consent, use the name Mali.
Mhm.
It's an issue.
Mhm.
So if that is the name that is registered in Mali,
Mhm.
so how do you distinguish, like, is it the dad or like the Mali who came after the Mali?
I don't think we can distinguish. I think it's meant to connote a family thing. It's meant to connote all the Malis before and after. Yeah, arguably. Yeah. Can be a family chain thing. Yeah. That's it?
So what I'm getting there, you're doing a joint thing.
Yeah.
Makosa unaweza fanya ni kukufa.
Makosa unaweza fanya ni kukufa na mkikufa at the same time, maybe in a car accident or something, the person gives and they can't determine the time of death for whoever. The person deemed to have died first is the eldest. So if you're older by a day, the thing goes to the person. If it's joint ownership, that is. So also be very careful with those joint things you guys do.
Assuming amekufa na wimbo yake kapatikana na copyright violation of another song labda, who will be held accountable?
The estate. They sue whoever inherited. You see, when you inherit something, you inherit both the liabilities and the assets. So if your relative dies, let's say, knock on wood, assuming a parent of yours dies and they owed me money, I'm gonna come after you. The estate that stays back is going to be liable.
What if I'm recording a video? It's not my video, someone paid for it, and in the background we have copyrighted music.
Yeah.
And who will be held accountable in case we have a case? The owner of the music or the videographer or the editor? Because
the owner, the person who paid for it, whoever has the copyright. Though I know there's a case, there is an ongoing debate, but there's a case where the court did find that the copyrighted work behind the scenes, ilipatikana kwa hiyo how do I put it? What you described, that was there by accident, so they are not held liable. But I don't know what is the merit of being there accidentally, or sometimes someone is shooting on a CBD na umepita tu hapo nyuma na video imekupcapture.
I think they settled it.
Yeah.
Because, remember when this musical big corporate came in, or TikTok and Instagram, when
Yeah.
people were like posting their music, and then at some point they had to release it how they can.
Yeah.
And I think they now go back, they say like if it's under a minute or something.
Yeah,
then-
they
yeah.
don't really look at it.
Yeah.
They seem to look at it like as accidental and not intentional. Yeah.
So long as it doesn't precede a minute.
Yeah.
Okay.
I think I agree. Alright guys. I think that's it. Thank you for your time. And thank you for listening to me. Thank you for your questions. I enjoyed myself, and I hope we'll meet in many other forums. Yeah. So thanks so much, Felix and your team.
All right, Makofi to our presenter. I have a question. How many did you enjoy? Can raise up your left hand.
I'm going to mark you.
But how many enjoyed the session? Asante sana. It's indeed it is a lot of knowledge that you gained over this time, and sometimes we say that even in the book of the Holy Book, that is Hosea, I think chapter 6 verse 4, it says that my people are perishing for lack of knowledge. So sometimes you might be suffering, suffering a loss from your trade just because you didn't have knowledge, and as a result, you might have gone into a loss by virtue of that. Now that you are enlightened, I think the goal is then now for you to a antenna. Then in communication, the masks are quite high. So the masks for information are quite high right now. So it is upon you to do research and understand what actually infringements you have. As Vanessa said, that IP rights infringements, it is you who has to become proactive to scout and see whether it has happened. And if it has happened, we have seen how to be able, or channels to report them. And once you report them, you can be able to get a remedy. Even though I know that there is no violation without what? Without a remedy. So for every violation, indeed there is a remedy to that. Even if you go to court, hata koti inaweza kwambia mazee pole. Isn't that a remedy? Yeah? Yeah, it is a remedy, yeah? Takwambia tu mazee, tumeona umegongwa lakini pole sana, yeah? Hata hiyo inasaidia cause unafili kama mtu amekusikiza. Yeah? Intellectual property things, it's, how, for example, Kenya, the Copyright Act was developed way back. Trademark the same, patent the same, but now they were developed even before internet came into place. So internet has come, there's issues of globalization, artificial intelligence. So those are emerging issues that are actually affecting your intellectual property. And I believe that is why even the current laws will have to undergo some sort of amendment to be able to incorporate all these things. I think you've heard through the Finance Bill 2026 issues of digital taxation and things like that. So those are actually touching on the things that we basically talked about today. Asante sana for all of you coming, and I think I want to appreciate all those who have made this day a possibility. I'll give Stella an opportunity to give a vote of thanks. But now, having that you came, this is not the end of our presentation. More is to come. But one particular thing that is coming up is a competition. It is a graphic design competition. We're going to give you Vanessa's PPT. We will share with you. You'll be able to use it for your understanding. Based from the same, we have an intellectual toolkit that we want to develop. So an intellectual property toolkit is to help even those who didn't come today to be able to have an understanding of what intellectual property is all about. It is intellectual property rights. I think that contextualizes the issue more solidly. It is the intellectual property rights. Because if you know about intellectual property, the question is, what next? But if you know about intellectual property rights, it means that if you realize that your rights have been violated, then you can be able to go ahead and ensure you are able to seek the remedy that is needed. So we're going to have to share that on our WhatsApp. How many of us within that WhatsApp group that we created? Who is not? Okay. So for those who are not there, we will be able to add you there. And the goal is that the competition is coming with a few conditions. We will also share the criteria of how we are going to award, how we are going to arrive at the winner, what it will be able to look like. So you will have all information before you start. Yeah? So that it helps you now to contextualize, to visualize, and now create some graphic designs that can be able to bring that to a level that any other layman out there can easily understand issues of intellectual property rights. And we are going to have and this is going to take a month, and after a month we will announce the winner, and the winner will be awarded here at Kamkunji Grounds for that matter. So the question would be, what do I stand to gain? The one who will become the best overall will be able to be awarded $100. You can check that in Kenya shillings. If you convert that with the spot rate, assuming the spot rate today is 125, that's about 12,500. Yeah. So the second runner-up will be able to be awarded $50. If you do 12,500 divided by 2, how much is that? 26,250. And then number 3 will also not go alone. He will go home with $30. Isn't that fair enough? Yeah. So that number 3 does not get much like number 1, isn't it? But for you, it is upon you to either be number 1, number 2, or number 3. It's you to make the choice. Yeah. None of us will be able to make that determination. The criteria will be so elaborate that even when you realize that your colleague has been awarded that, you will not feel like, it is going to be a fair and square game. And out of that, we will be able then to have developed that toolkit, which we will be able to use not for commercial purposes, but for purposes of ensuring that each and every other person whom we want in Kenya, in Kibera, which could be in any Islam, who would want to learn about intellectual property rights and get that toolkit, read through it without even going through the session like yourselves have gone through, and be able to have a good understanding. The beautiful part about what we have done today, it's already recorded. It is already within your WhatsApp group. You can be able to view that once again, and in case you feel there's somewhere you didn't learn more, or you want to get the emphasis as Vanessa had put it, you would be able to do that. There's beauty in, in terms when the teacher is presenting a concept and explaining it. There are some of the things that were explained here that are not part of the PowerPoint. So if you read both, you will be able to benefit more. So it is beneficial to you, and I want to appreciate this session was so good. We were supposed to close at 12:45, but we've done an hour extra. So I'm sorry for that, but I believe Stella is going to offer a vote of thanks and also let us know after this whether after the fellowship if there is a swallowship. Thank you, Stella.
I won't take a lot of your time because I think whatever we are here for, tumepata. Kuna artist yote anataka kupeana voice of thanks ama anataka kuambia wa trainer something today? A message?
She has said she's going to give us one.
Most of them have been doing about for example, say kama first time alikuwa Uruguay alikuwa missionary
kama au hizi training zitakuwa zikuwa mtaani ama itakuwa tu once in a while alafu zinaisha.
Only firstborn for party. You are the pioneers today. When you make one first beneficiary, spread the word. So next time to share, people take it seriously. Because you see, at most 30 people applied. Wakanyima wengine chance. So wengine walikuja baadaye, they didn't get the opportunity. But at most, half of the people showed up. The rest spoke up. You understand? So inamaanisha in our community bado tuko kwa level yenye we don't really take things seriously, na si kubaya, ni juu mostly tuna feel like tunatumika, sindio? But beyond the training, Felix mentioned we are going to have legal clinic here. Legal clinic inamaanisha ni mali anytime uko na issue you can always come in and get guidance. Doesn't have to be training. Okay. And then again, the toolkit competition need to we can push it throughout to everyone in the community, other beyond, to understand what is their right, what they stand to gain and all that. Because I believe like today's generation go well equipped na knowledge iko everywhere. It's just that sometimes you don't know where to go to get the help. But Humanist Project now is here to have this journey going on, and we've collaborated with Lawyers Without Borders. And then you never hear about them again. If it's something that we may connect you with Lawyers Without Borders, why not? It doesn't have to be training people, but more of opportunities that can protect you or can help you make money. Because Kibera, most of people tunakoga sani for 20 years, lakini to grow beyond Kibera. You know why? It's because maybe hatujalan to take our art commercially. Wewe unaitwa tu event, Stellana kwambia niko na 10k. Wewe una sign tu na perform unaenda home. Ndio. But then again, tumezoea kusema ni platform unapata and everything. But training like this na kufundisha how you can monetize your work without only depending on the platform or unapatiwa do for that day. More of commercializing what you do in the right way, right? Yeah. So I think to see what it can do.
Africa is your training. Nimesema anaongelea kuhusu sana graphic designers na wengine wetu si graphic designers, so niko na designers peke yao ama ndio singine.
Unfortunately, graphic ni poster. Toolkit ni more of ni visual or something, sindio? So kwa saizi lazima tu nimbokaa, wacha kusema nimbokaa design yenye whatever unaona kama leo tumekuwa na training like from morning mpaka saizi. Now we are looking for something that ana mama mwenye anaimba kwa kwaya anaweza angalia na communicate very directly to them what their IP or rather what is IP. So at some point maybe an opportunity may come for photography in future, but saizi maybe unaweza jaribu kuko broker mwambie mtu chora then tukubaliane ukishinda unipe cut, ndio? Yeah.
All right. Just to answer your question, in addition to what Stella has mentioned, all of us, how many of us know how to use a computer? Yeah? How many of us can put a picture in a Word document? How many of us can add words to that Word document? You're already a graphic designer. It's as simple as that. So you don't have to really, have some sophisticated kind of a thing. As long as you can imagine this is art. Just the way, for example, it's a song. It's art and you want to put a picture and words to it. You can be able to do that. And then another thing is that a number of us have walked along Kibera, and along the walls you can see some inspiring paintings on the walls, murals. There's something that you can be able to see there, and you want to import that to this. You are free to be able to do that because it gives you an idea. You can transport that into this. And the goal, even those who've done those murals, their aim is to spread that out for many people to be able to understand. So we will also have a graphic designer who is also going to guide you when you have questions within our group. If you have a question, you can be able to reach out to those graphic designers. One of us who is seated just amidst of us is a graphic designer. I want just him to raise his hand. Benjamin. Yeah, so Benjamin there is a graphic designer. He will be part of us through the program. So you can actually raise up and say, I need this. Eventually we will have, a graphic designer put all the things that you will be able to put. It could be like, for example, Rihanna, she knows how to do songs, isn't it? Not graphic designing. Through her song, she has words that can be encrypted into a picture that she can randomly tell. And that might end up becoming the winning document at the end of the day. So don't limit yourself that I have used the big word graphic designer and say I'm not going to be part and parcel of this. Take it, it could be a poem. Perhaps you want intellectual property disseminated to others through a poem. You can say, niko na pesa, lakini bila knowledge, hiyo pesa siezi ipata. Same thing that you actually have today. Today, if, for example, we had put in our training program that if you came for the training, you will be paid 5,000. How many of us could have missed this training? None of us could have missed, isn't it? But now, the knowledge that you have, if you quantify it, isn't it more than 5,000 today? If you can go with that knowledge itself, assuming every other person who are in the art industry like yourself have no knowledge of the same, the way you can be able to use it, the way you can be able to commercialize it, you will be able to reap benefits way more than that 5,000, assumedly that you could have been paid today. So sometimes opportunities ni kama gari, ikishatoka stage, imeshafanya nini? Imeenda, labda utangoja ingine. Thank you.
Yeah. I think Felix has said it better. So Kenya amemaanisha ni usijilimit. Ndio, unaweza kwa wewe designer, but you can direct something and try your luck. Ndio. Yeah. Nini, mashindano ndio itaamua. Mashindano ndio itaamua. Pengine itakuwa bahati yako. Yeah, bahati yako, si ndio? So yeah, I will share a feedback form. I'll share a feedback form to take feedback how the training was, you know. And then again, we'll appreciate if you pass the information around, because as much as we are in the high century, word of mouth bado inatamba sana. So after this, we will head to the cafeteria. We will be served lunch, right? Yeah, and then Rihanna will close for us. She has a full presentation.
Sikuwa kufana, nikiona tabasamu lako, najawa na furaha. Sitojidanganya, nikuache uwe peke yako, mahaba yanijaa. Hisia zanichanganya, zanifanya niwe kicha na mambo bado, nashindwa kujitoa kwako. Nalala nikikuwaza, nashinda nikikutaka, uwe kando yangu, we wangu na mimi we wako. Uwepo wako, mambo yako, uzuri unatoka kwako, nayo nafasi kwenye moyo wangu. Mienendo yako, sifa zako, upendo kutoka kwako, nakutamani kwenye moyo wangu. Ni sina wasiwasi, kwa kweli sina nikiwa na wewe.
Yeah, sasa ni hayo kwa sasa. Thank you so much Vanessa. Mmepata namba, si ndio? So at least that is extra contact or that of a networking opportunity. So at least tutasema najua lawyer, si ndio? Yes. Yeah, sorry, it actually forgotten. On our way to the cafeteria, we can have a good photo just to remind us about today. You know? Yeah. Thank you so much and see you next time.
Subscribe, stay guided.
Tutapika hapa na mbele ya HNP. When I grow up I want your phone. Lakini pesa ndio sijatoa wapi.
Pesa inakujanga. Itakuja.
Video hiyo kitu ni safi.
Safi. Umeoshiwa live? Buka muone saa hii.
Video hiyo kitu ni safi. Ni safi sana.
Bado niko live.
Family of Hope Church. I am ready. Hiyo ni ya kwanza. Amujasikia. Isi live.
January 1995. Alikuwa anachelewa kwa mchezo zake kwa kando kwa DP. Hata bado hajacheza. Ndo simu.
Okay, I'm ready. Mpege mujasikia. Owen, unaniharibia picha. Aya, niko ready. Okay, ndio hiyo picha nakuja. Sawa sawa.
Same smile.
Okay, in 3, 2, 1. Another one. Asanteni. Alifanya hivi.
Nani? Ampatie pilau yake.